May I please a lot? My lord, item number 60, my lord. The item became infractuous. The matter became infractuous. I have informed the other party. Is item number 15, admission column came. 60.
3 M.J. Kadir, counsel for the petitioner, has submitted that by a flux of time, the matter has become infractuous. The petition is according to Mr.
Obligement.
Yeah, please, Your Lord. With your lordship's indulgence, I would like to list the CRP 192 on next Wednesday.
Fresh matter.
No, it's not a fresh matter. Returnable period is already over.
Matter of which year?
2023. Just last month it was filed, and interim order was passed by this honorable court, and that interim order needs to be extended. It was only till the returnable date.
Okay.
All right.
May it please your lordship. In regard to item number 3 of
This
the
will not take up.
I thought so, but I did not manage.
List before any other bench. Sir.
Obliged.
May I please your lordship? Lordship, I have to mention item number 23 of today's daily list, your lordship.
Yes.
Kindly the matter be adjourned, your lordship, with the consent of the other side.
You for the petitioner.
Yes, your lordship.
Appellant.
Appellant.
After a week,
After a weekend.
on a prayer made of the
Obliged.
May I
Yeah,
please, your
yeah,
lordship?
yeah,
My lord, I would like to mention item number 11 of the daily list.
Yes.
With the consent of the opposite side, I prefer a short time to file our objection, my lord.
you're for the respondent.
Yes, my lord.
What is your name?
P. Bhagat.
E. Bhagat.
Yes,
You're
please.
for whom? You're with whom?
B. Sharma, junior of B.
Okay.
Sharma, my lord.
You informed the other. You're for the other side. I'm P. Bhagat, Planet Council, appearing for the opposite parties. Praise for and it's granted 2 weeks time. 2 weeks time to file objection. Please.
Let this matter will take a fixed date in the month of August. 23 or 25.
Madam, we fix the date. Please on
23 or 5.
as agreed to by the parties. Please on 23rd of August.
Deeply
Obliged.
May it please your lordship. Lordship, I beg to mention an item number 36, your lordship, of the daily list, your lordship. I am making this mention on behalf of Mr. P. Bodler, your lordship, for the respondent.
Yes.
Lordship, the learned counsel is awaiting certain instructions, your lordship. So, upon his instructions,
And from the other side,
yes, with consent has been taken, your lordship, from the other
a
side.
prayer has been made on behalf of P. Butler, Planet Council for the respondent for adjournment. Please after a week. And on
After
the
3
ground,
weeks,
on the ground, that some instructions are awaited. Please after 3 weeks.
Deeply
May I
obliged.
please, your lordship? Lordship, I beg to mention one CRP for listing in admission.
Which
column.
year? CRP of which year?
CRP of 2022, my lord. It was lastly listed on 26/9/2022.
What is the purpose you want now?
My lord, we are denied the mandatory injunction by the additional district judge below.
You are the petitioner.
For the petitioner, my lord.
Okay, we'll have it when? When do you want?
On Monday, my lord.
Monday is not possible.
Any convenient day on next
Friday.
Published.
Give the date next Friday.
May it please your lordship. Your lordship, I beg to mention item number 14, your lordship.
1-4.
1-4, your lordship.
Yes.
Due to ill health of my senior, your lordship, the matter will be passed over for the day, your lordship.
It is submitted as pre-RK here. Senate Council is not well. Full stop, Sarah. List after a week.
Notice on MF matter of 2014. Yeah, so last listed on 29/3/2023. It may be listed on 2nd August order.
2014 years.
14.
May I please your lordship? I beg to mention item number 7 of the daily list.
Yes.
My lord, due to the ill health of my senior,
Okay.
my lord, the matter may be,
From the other side.
yes, ma'am.
Yes.
My lord, the matter may be fixed on Monday, my lord. Some urgency.
Monday is not possible. Wednesday.
Yes, ma'am.
GMT has done council for the petitioner submits that his senior PE Sattar is unwell, full stop. Unwell and therefore prays for a short adjournment, full stop. Also had PE equal and for the sole respondent, full stop, para, as agreed to by the parties, based on what is stated.
Highly ordered. May I please your lordship? Lordship,
Second,
Lordship, I beg to mention civil revision petition 50/23 for admission. Matter may be listed on Monday,
of which year?
23.
Not on Monday, Monday not possible.
Any convenient day?
When was it last listed?
Last listed 23/5.
We'll have it on Friday next. If Friday is date, it will be, I think, 4th of August.
Please, your
Alright,
lordship, I beg to mention the matrimonial appeal, lordship, for listing. Any date?
Fresh matter.
No, lordship, 2022 matter, lordship. It was last listed on March.
What is the stage of the proceeding?
Lordship,
What is the stage of the proceeding here?
lordship, we are the appellants, lordship. Actually, ex parte order was passed against us.
Now,
Yes,
what
sir.
is the stage here?
Stage lordship, actually, we had filed an IA, that filed an objection regarding the.
I is yet to be considered.
Yes, lordship,
Okay, Friday next.
lordship, obliged.
Minor item number 65, I may be permitted to withdraw match.
We proceed with five.
Supplementary list.
Three H.K. Sharma, learned counsel for the petitioner submit that he has instructions to withdraw this petition. Put according to petition, this on withdrawal. Madam, you have for?
Much obliged.
Lordship, I beg to mention item number 40, 41, and 42 of the daily list. I'm appearing on behalf of the review petitioners, on Lordship, behalf of Mr. D. Nath.
We have objection, lordship, regarding first.
So, Lordship, we have to file an affidavit. So just 1 week's time may be granted, Lordship.
If he is objecting, we have to
Lordship,
take up
earlier
the
also-
matter. We may
Yes.
grant you time when the matter is taken up.
Lordship, obliged.
So what is the purpose you are seeking an adjournment?
Lordship, as per instruction,
Now, what is the purpose? Why do
to
you need
file an
time?
affidavit, Lordship. We
You
have
need to
to.
file an affidavit.
Yes, Lordship.
Let them file the affidavit.
Actually, there is no
Lordship, just
problem with
1
that,
week's
but,
time,
uh,
just-
Earlier also, they mentioned a matter without taking our consent. And today also, they are mentioning the matter. So.
Today
we
consent has
have
been
some-
taken or not?
No, lordship, from our side,
I was just informed about it, Lordship, and
that is the problem.
Madam, this
Madam.
is not fair. You should inform the other
Lordship,
side.
let the matter come up.
We would have given the adjournment. Now, since you have not taken consent, you have to take, you have to wait till the matter. is-
Lordship, obliged.
Obliged, lordship.
Right, please, your lordship. I have instruction to withdraw this petition, my lord.
Ricky Barua, counsel for the appellant, huh?
Appellant.
Or I in terms of
Obliged.
Mr. Das says that this matter was heard on earlier occasion.
Lordship.
Record was directed to
And
be.
record was also produced by this honorable court, lordship.
You have the records now.
Yes, I have the reconstructed record.
Then I can go ahead to the
Lordship.
one thing. Let's see how many motions are there. Let us complete the motion, then we take up this because this is going to take time. We'll take this for disposal. We have around 12, 14 motions. So this will not take much time. Motion to approve. Transfer.
Transfer petition. From Masulpur to Udalguri, Your Lordship.
Musalpur to Nalbari. What is the distance?
200,
Huh?
200 kilometers.
Musalpur to Nalbari is 200 kilometers.
Masulpur to Udalguri means
Udalguri.
Udalguri,
We had Nalbari.
not Nalbari, Your Lordship. And the petitioner has filed a petition under section 125 CRPC for maintenance, and that is pending at Udalguri, Your Lordship. So after that,
You are the wife.
yes, I'm the wife,
You are presently staying at Udalguri.
Udalguri,
Your 125 is at Udalguri.
yes.
Now, what has been filed at Musalpur?
Masulpur, the husband has filed a restitution petition, Your Lordship, later on in the year 2023, Your Lordship. Recently, that has been filed, Your Lordship.
What is your difficulty? What are your grounds?
My ground is, first one, that he is not paying the maintenance amount. Instead of passing the interim order, there is an interim direction, but till that he is not paid any amount. That is one of the ground. And next is the 206,
That is not a ground for transfer.
206 kilometer distance, Your Lordship. So,
Even he has to come 206 kilometers for testing the maintenance fees.
oh, Your Lordship, his wife, Your Lordship. So,
All are
See-
equal nowadays.
he has
You
to,
cannot conveniently say that I am the wife, now I cannot do. If something else happens, no, we have to equal. Because is equal.
no, Your Lordship.
We have to be consistent.
No, Your Lordship, he has also no problem because he is staying at Swalkushi at present. Husband is staying at Swalkushi.
For
He is an employee,
employer of what?
a government servant, Your Lordship.
Of which department?
That department is, I have no instruction, but he is
You
working.
don't know, you are the wife, your husband, where he works, you do not know.
No, at Swalkuchi.
Where he works, in which department?
Probably teacher, Your Lordship. Head teacher.
Probably. Where do you work? Where do you work?
I'm not working, Your Lordship.
You don't work.
No,
Even at home, you don't work.
no. I am residing at parent house at present.
You don't work at your home.
No,
You don't work at all.
no, just a house. Just-
Household work.
Yes, household work. That much, Your Lordship.
Your grounds are not enough. sufficient.
No, Your Lordship, there is an other ground also. If Your Lordship go through the petition,
Yes, tell us.
yes,
We're-
he is
we're-
torturing me. Yeah, Your Lordship, then you have to come to the phase 4.
4 years, we are at 4.
The petitioner back to state that 1 month of the solemnization marriage, the respondent used to smoke cigarette, drink liquor, and instigating his brother Rajkumar Chetri, he used to scold using filthy language.
We have read this, but what are these your grounds? These are allegations that what has happened.
Allegation, Your Lordship.
But grounds of transfer, that's different.
Your Lordship, she cannot go there because her brother is also disturbing her. His brother is also disturbing her. So if she visit the Musalpur, there is life threat.
Where have you stated?
Yes, it is there, Your Lordship.
Where, tell us. That there is
Something respondent scolded her and asked her to keep mum, threatening her that he would finish her life despite the parents and her relatives at the time of marriage gifted.
That was something earlier. Now, where have you stated that if you were to go to the court at Musalpur,
Because of that, she left the matrimonial house and she is staying at parental house. And he is not paying anything, Your Lordship. So where from I get?
that you have the recourse in law. If he is not abiding by the court's order, you can inform the court.
Yes,
I don't think there are sufficient grounds. Third, Sri N. Upadhyay, Senate Counsel for the petitioner who by means of this petition filed under section 24 of the Code of Civil Procedure 1908 has paid for transfer of TR within bracket R side of case number 6 of 2023 from the learned court of district judge Bakta Masalpur to the learned court of the district judge Udalguri. The state proceeding arises out of has been instituted by the opposite party has been under section 9 of the Hindu Marriage Act 1955. The Upadhyaya, the learned counsel submits that after solemnization of the marriage on 14/5/2021, the petitioner was harassed and tortured, for which she had to leave her matrimonial house and is residing at her parental home at Udalguri, whereafter she had instituted a proceeding under section 125 of the CRP in the competent court at Udalguri. It is further submitted that in spite of interim order of maintenance, the same has not been complied with. The Learned Counsel has also expressed grave serious threat and threat if she is required to attend the court at Masalpur, and therefore the instant petition has been filed. Issue notice returnable on when is the next date?
Next is 8/7 or 7/8. August 7, this date.
Returnable on 23rd of August. That step be taken for service of notice upon the sole respondent by by Monday. Sir, the Learned Counsel prays for an interim order. Sir, considering the facts and circumstances, it is directed that till the returnable date, further proceedings into the date of the agreement.
Obliged.
Wait, please, Your Lord. My lord, this petition against my lord,
Who has christened your name?
My lord,
Who has put your name? Who coined your name? What is your name?
Adalat Mia.
Talat.
Yes, my lord. Adalat Mia approached me before this Adalat.
Why do you come to the court then?
My lord,
You should not come to the court.
that is why he himself unable to settle the matter. That is why he
You are
approached
the
another.
court. You have assigned yourself with the court. Okay. Mr. Adalat Mia, what is your case?
My lord, the petitioner here, my lord, was defendant in the title suit of 10 of 2017.
You are a defendant.
Yes, my lord.
Okay. Good for?
Suit for specific performance of contract.
Okay.
The plaintiff filed that suit claiming for decree directing the petitioner defendant to execute this registered sale deed in favor of the plaintiff on the force of an agreement. The petitioner claimed that agreement was manipulated. The petitioner admitted that he received an amount of rupees 2,40,000 and by putting signature in a blank stamp paper. And subsequently, the plaintiff respondent took registration one plot of land in favor of his wife, in the name of his wife.
But the sale deed is registered.
Yes, my lord.
Isn't the presumption against you?
That is, my lord, separate plot, my lord. The
You have said that the petitioner, the plaintiff has filed the specific performance suit for execution of the for performance in view in connection with the registered state deed.
Yes, my lord. Not a registered deed, my lord. The petition filed for claiming registration, registered sale deed. That was not done. But the petitioner said that on the basis of
What is the release in the suit? To get the sale deed registered,
yes, my lord,
to get the sale deed registered.
to direction for registered sale.
That is it.
Yes, my lord.
And you say that the agreement was not proper, it was initiated by fraud or something.
Yes, my lord.
What is the fraud involved?
My lord, that is my lord, the agreement at page 8, my lord. Page annexer 8, page 78.
Let us come to the impugned order.
Impugned order, my lord, at page 66, my lord.
66.
Yes, my lord. Against that expiry order, he approached the same court by filing a petition under section order 9 rule 13 that was rejected, and subsequently he approached before the additional district judge filing miss appeal. That appeal was also rejected, and challenging that appellate order, petitioner approached this honorable court.
The matter is slightly different. There's an initially the appeal was filed by whom against by you against which order? Page 66 order has been passed in respect of which order under challenge?
That is in
Let us
respect.
see the first order.
Yes, my lord. In respect of annexer 6, page 60, my lord.
60.
60.
Order dated
14/12/2022.
by whom?
By Ms. J.
No,
is
by whom?
by the petitioner,
By which court? Civil judge.
civil judge. It is, my lord,
Civil judge Borpeta.
civil judge Bopeta.
Okay. What was the case? Let us see. This was to set aside expert day.
Set expert.
Let us see the expert order.
Expert order, my lord. Page 37, my lord.
First you should show 37. You are going
Annexer
backward.
3A, my lord.
37.
37. The operating part order at page 43, my lord.
Page 40.
43.
This is order dated 10th of November 20. Yes. This is judgment.
Yes, my lord.
Where is the operative portion?
Operative portion, my lord, order. Page 43, order, paragraph 14.
Refund of 12 lakh.
Refund of 12 lakh.
Okay. This was expert day.
Yes, my lord.
Let us see where it is. Where is the discussion regarding expert day? Did you file WS or not?
My lord.
Did you file WS?
My lord, I have filed the application, my lord.
Did you file WS or not?
No, my lord.
You did not file.
No, my
petition. Did you receive notice?
Notice received and appeared and filed a petition claiming that they are for furnishing documents. And subsequent date, the court was declared as holiday. And subsequently, he left the district and reside outside the district and suffering from illness. During that period, lockdown was started, and he failed to appear. And on that count, my lord, the engaged counsel also not appeared, and the case was decreed expired, my lord.
You are not required to appear personally. You can, if you engage a counsel, it's a civil proceeding. This is gross negligence on your part.
Yes, my lord.
What fault can be attributed to the court? If you are not appearing, not taking steps, the suit is of the year 2017
Yes, my lord. And the
and the
judgment
judgment is of 2020.
20, my lord.
After 3 years, that to October 20.
And the main thing is this, my lord, here also, my lord, the agreement which is under,
We are not going to the
My lord.
we are not going into the
My lord.
magistrate case. We are here only to see whether the decision to go ahead with expert is proper or not.
either way, my lord, petitioner may be just allowed to contest the matter by imposing lump sum cost, my lord. Otherwise, my lord, conduct is not good. And some day will come, he will homeless, my lord. That is his residential land, my lord.
Has the execution started?
Yes, my lord.
Execution started.
He started.
What is the execution case?
Execution, after receiving notice, immediately he approached the executing court by filing an application that was rejected. Subsequently, he approached civil judge and additional district judge. And during pendency of the misappeal, the proceeding of the execution case kept in abeyance. And thereafter, no date has been given,
We'll issue notice here. We are not going to stay.
my lord. And just, my lord, proceeding of the execution,
We are not going to stay. Their conduct is not proper.
it is
Let
admitted,
us
my
see
lord.
if they come, if they agree upon some cost. Otherwise, we don't find any case to be made out.
My lord, lump sum cost may be imposed.
Without hearing, why should we?
Yes, my lord, notice may be issued, my lord.
Third, CKU Amit Planet Council for the petitioner who has filed this petition under Article 227 of the Constitution of India against an order dated 8/6/2023 passed by the learned additional district judge Forfeita in Miss Appeal number 01 of 2023, which was filed under Order 43, Rule 1 within bracket D, against an order dated 14/12/2022 passed by the learned civil judge Forfeita in media case number 84 of 2022, arising out of CS number 10 of 2017, by the aforesaid order dated 14/12/2022, the application filed under Order 9, Rule 13 by the petitioner to set aside ex parte judgment dated 10/11/2020 has been rejected. Issue notice returnable on on 25th of August. That kept for service by registered posted by Monday. Except
By registered post, my lord. Obliged.
yes, Mr. Kolita, what is
Lordship, here, my lord, the claim application, my lord, MSC case, my lord, was filed beyond the period of 6 months of limitation, my lord. Because Lordship, under section 166 subsection 3, there is a newly inserted clause, my lord, that no claim application shall be entered in unless it is filed within 6 months of the date of occurrence, my lord. Now here, my lord, the date of accident was 15/7/2022, and the claim application was filed on 2/2/2023, my lord.
Let us see the order.
Lordship. At page, my lord, 22. Along with the claim application, my lord, one miscase was also filed under section 5 of the Limitation Act, my lord. Lordship, the miscase has arisen out of the petition number so and so filed by the petitioner claimant praying for condonation of delay in filing the claim application under section 166 of the MB Act 1988. Seen the petition, our learned counsel for the petitioner issue notice to the opposite parties. Petitioner to take steps by registered post
Now,
7 days.
by which order are you agree?
Lordship, this is the order because the claim application was registered, my lord. It was numbered, even though it was filed beyond the period of limitation, and the order dated 5/4/2023, my lord. Lordship,
Where?
this
Page?
is at page 32, my lord.
Yes.
Page 32. Because, my lord, there is a miscase, my lord. The miscase was also order was given on 5/4/2023, whereby the delay petition was allowed, my lord. But
Where is
in
that
case,
order?
lordship, this is at page, my lord. Page, my lord, 29, my lord.
29.
29. This is passed in miscase, my lord. But there is no provision for extension, my lord.
Where is the newly insert provision?
Lordship.
Page?
Newly inserted provision, my lord. This is in, my lord, 166 subsection 3, my lord.
So you have given some gazette notification, I think.
Yes, lordship. Because that notification, my lord, the amendment was given effect to.
Motor vehicle sec. Yes, which page here? You have seen some notification.
Yes, lordship. That page, lordship, 35, my lord. That by this notification, my lord, the amendment was given effect to, with effect from 1/4/2022, my lord. And the accident took place subsequent to the coming into the effect of the notification, my lord.
Yes, what is in case of date of the coming into effect?
Yes, my lord. Page 35, my lord. The notification I have annexed, my lord.
This amendment is of which year?
2019, my lord.
Section 166.
Lordship, 166 subsection 3, my lord. Lordship might have got it.
Why section 5 will not be applicable? Have you taken a point that 5 is not applicable?
Lordship, I have taken up, my lord.
Why?
Because, my lord, of course, this is not specifically excluded, my lord, but this is
This is an
implicitly
application.
excluded.
This is an application.
Lordship, because, my
This is
lord,
not a suit.
yes, my lord, my point is that, my lord, this is, there is no provision for extension in the section 160 section 3, my lord. But whereas, my lord, in section 173, my lord, while filing appeal,
Is there any inbuilt mechanism for limitation? There is no.
there is no,
So if there is no inbuilt mechanism of limitation, we have to fall back on the Limitation Act.
no, lordship, I beg to differ, lordship. My point is that my humble submission is that, my lord, this is, although it is not explicitly excluded, my lord, but this is implicitly excluded because in section 173 of the MB Act, my lord, there is a provision for extension of period for filing limitation, my lord. But my understanding that the
173 is an appeal.
appeal, my lord, yes, my lord.
It's an
In the
appeal.
same act, my lord, there is a provision for extension of time.
Yes.
But in this, but in section 166, my lord,
Something in 173 which provides for condoning the delay and prescribed period of limitation is also there.
Yes, my lord.
Now, it can be read along with limitation act. But here there is nothing to show that limitation act would not be applicable. It is an application.
Yes, my lord, but lordship, for that, my lord, I am relying upon a judgment, my lord. Every judgment, my lord.
We're not going to exclude an application for MSCP for delay.
The lordship,
Don't come up with this petition. Let us we deal with the judgment.
lordship may kindly have a
It is
look
a
at
suit, matter is
para
different.
24, my lord.
Somebody has passed away, a 6 months delay, and you are taking a point. Are you disputing the accident?
Not at all, my lord.
Then,
Because there is a specific
yes,
provision, my lord,
which paragraph?
para 24, my lord, of the judgment, my lord. This is of some other act, my lord.
Not applicable. Yes, but critically, when it comes to for the petitioner who has filed this application under Article 227 of the Constitution of India, challenging an order dated
Lordship, may I beg to interrupt, lordship. One more submission, my lord. Because, my lord, regarding that aspect, my lord, the Honorable High Court of Telangana, my lord, had passed a judgment, my lord. But that judgment has been stayed by Honorable Apex Court, my lord. That I am placing, my lord.
what were the facts?
Lordship, the claim application was filed beyond the period of limitation that was rejected, my lord. Then the petitioner approached before the Honorable High Court, and the Honorable High Court had directed the MSCT to register the claim, my lord. So against that order, the insurance company approached the Honorable Apex Court. That judgment has been stayed, my lord.
What were the two issues here before the Honorable Telangana High Court?
Lordship, that aspect also was taken up, whether the application of Section 5 of the Limitation Act should be applied.
No, while disposing of, there is an observation.
Observation that the claim
larger
application
question
should be
is,
registered.
Larger question would be is left open. What is the larger issue involved?
Section 5 of the Limitation Act, my lord, whether it should be applied or not. And the claim application was directed to be registered by the MSCT, my lord. Against that order, the insurance company approached the Honorable Apex Court, my lord.
please follow now. Equally, the learned counsel who, for the petitioner who has filed this petition under Article 227 of the Constitution of India, read with Section 151. Full stop. The petition has been filed against the order dated 5/4/2023, passed by the learned MECT Gwalpara, by which Miss Case number 6 of 2023, filed by the claimant for condemnation of delay of 19 days in filing the claim petition, has been allowed.
Yes, madam.
Full stop. The learned counsel has drawn the attention of this court to Section 166 within bracket 3 of the Motor Vehicles Act 1988, and has submitted that the state provision has been inserted by the amendment of the year 2019 and has been given effect from
1/4/22, my lord,
1/4/2022
2022.
and also by the state section, a period of limitation has been prescribed to be 6 months from the date of occurrence of the accident, and it is submitted that in the instant case, the accident had occurred after coming into operation the state provision of law. Full stop. Para. The learned counsel has also placed before this court an order dated 4/5/2023. No, this court is of the opinion that since it is an application which is filed under Section 166 of the Act of 1988, there is no reason as to why the provisions of Section 5 of the Limitation Act will not be applicable. Apart from the fact that the delay in the instant case is a minor one of 19 days, the entire object of the Act of 1988 is entirely, and the act in question is a beneficial piece of legislation which is required to be given an interpretation which is in sync with such objective. The learned counsel, however, has placed before this court an order dated 4/5/2023 of the Honorable Supreme Court, whereby an order passed by the Honorable Telangana, by a division bench of the Honorable Telangana High Court, has been stayed. This court has noticed that the applicability of the Limitation Act has also been and this court has noticed that the Honorable Kerala High Court has also taken the view that Section 5 of the Limitation Act would be applicable while construing Section 166(3) of the Act. And in this, reference may be made to a case to a case of Akshay Raj versus Ministry of Law and Justice reported in so and so. Be that as it may come up, that notice be issued. That step be taken for service of notice upon the respondent by registered post CCT steps within Monday. The returnable date is fixed on when? On 25th of August. The learned counsel prays for an interim order. The interim prayer could be considered on the appearance of the parties on the returnable date.
Lordship, on 21st of August, my lord, it's fixed for written statement by us, my lord. 21st of August.
You can find
So, my lord, at least, my lord, till returnable date, my lord, stay may be granted, my lord. Till returnable date, at least, my lord.
without telling we are not. In fact, we wanted to dismiss it cost, but there is a Supreme Court order. We would have imposed heavy cost.
Lordship, the provision starts with non-obstante clause, my lord. No, my lord.
Yes.
Much obliged.
Yes, Mr. Chaudhary, what is this?
May please the lordship. Lordship, this CRP has been preferred against rejection of an injunction order.
Rejection by which court?
Rejection by the appellate court, your lordship. Both the orders have been under challenge. The trial court on the very first date had granted an ad interim ex parte injunction, which was later on, after hearing both the parties, the same was rejected. An appeal was preferred against the same before the appellate court.
So
That was also
Suit
rejected.
is for
So, to your lordship,
petitioner is the plaintiff appellant.
right title interest, your lordship.
You are the plaintiff appellant.
Plaintiff petitioner, your lordship.
Suit for declaration of right title interest.
Declaration of right title interest of the plaintiffs as well as the pro forma defendants.
Yes. What had happened? What is the property?
Property, your lordship, is actually an Ismaili in nature. It's a huge property of 79 bighas of land. Predominantly, it has been used throughout the times by our predecessors and thereafter by us for the purpose of community grazing ground. And thereafter also for the purpose of using it as a cremation ground for the family members.
Hmm.
In the year 2018, your lordship, suddenly we came to know that the pro forma respondent number 1, who is also the defendant number 1 in the suit, had visited the suit property with court officials for the bailiff and bailiff, etc., for the purpose of executing some decree. Thereafter, in the month of September 2018, we came to know that a decree was passed in his favor and a seal deed was also executed in his favor. Now, the defendant number 2,
Decree and seal deed in favor of respondent number 1.
defendant number 1, respondent number 1. Earlier, lordship, a suit was also pending between the respondent number 1 and the respondent number 2. A suit for specific performance was filed with the respondent number 1 against the respondent number 2. wherein the respondent number one suit was decreed and a sale deed was executed in his favor.
Hmm.
Thereafter, your lordship, he proceeded with execution. When he proceeded with execution, only then we came to know, because we were not meet parties to that suit. Defendant number two otherwise is also a co-owner of the entire property, suit schedule 1 property, which is mentioned in the plain. So we were not meet parties to that specific.
That visited the area, thereafter what happened?
Thereafter, your lordship, upon coming to know, we had approached the executing court. We had filed petitions before the executing court, bringing it to the notice of the executing court that this is very well an Ajmali land which has never been partitioned. And as such, a sale of a property is not correct in its nature. And therefore, thereafter we filed a suit challenging the veracity of that very order and the sale deed which was executed thereafter. Since
You filed a separate suit,
we filed a separate suit thereafter, your lordship.
this
Challenging-
particular suit.
This particular suit, wherein we had filed an injunction application. What happened, your
You
lordship?
did not take recourse of 21,
21, 29, particularly that provision recourse was not taken, your lordship, but appropriate applications were filed before the executing court.
2197 gives you the recourse, why you are not required to file a separate suit? And he has a decree,
Yes, your lordship, 2197 states that if my
and
land,
in the present suit, you have filed for what? Have you
Right.
challenged the decree?
challenge the decree, your
You have
lordship.
challenged the decree.
Challenge the decree.
Where does the plaintiff?
The prayer, your lordship, is at page 46.
46. Yes,
Here, your lordship,
second prayer,
second prayer.
decree declaring the decree.
That brings schedule 3, your lordship finds it at page 48.
Let us see now the rejection of the first court, trial court rejection order.
The relevant portion, your lordship, starts from page number 109, the
It
reasoning.
starts at
Page number 109, your lordship, the reasoning starts.
no, it starts, where is the order?
The order is from page number 106, your lordship, annexure 7.
106. Order dated 11/12.
11/12/2019.
This is by whom? Civil
By
Judge
civil
2.
judge number 2. Executing court, your lordship, is the civil judge number 1.
Now, let us see the discussion at 109.
Discussion, your lordship, starts from page number 109,
109.
bottom portion.
Yes. Please read.
Thereafter, I have gone through the main suit at length and have also gone through the documents in the case record. Now, stitching everything on record, it seems that the plaintiffs have basically filed this petition praying for temporary injunction on the ground that the opposite party number 1 with a malified intention has been trying to proceed with the execution case and to deprive the plaintiffs from their legitimate right of use and enjoyment of their land. The main suit is in the stage of filing written statement by some of the defendants. In the main suit, the plaintiffs have prayed for a decree declaring the right, title, and interest over the land described in Schedule 2 of the plain, and for declaring that the decree dated 18/9/2017 passed in title suit number 119 of 2017 of the Court of Learned Civil Judge number 1, Kasar, Silchar, is illegal, fraudulent, and not binding upon the plaintiffs. The plaintiffs have also prayed for declaring that the execution case as stated above is collusive. Per contra, the opposite parties pleaded that the petitioners have no right, title, and interest over the suit property, The opposite parties further plead that opposite party number 1 is the bona fide purchaser of the decretal land through a registered deed of sale executed by the Court of Learned Civil Judge number 1 Kachar Silchar in title execution number 30 of 2017. Hence, from such rival contentions as regards the claims of the plaintiffs and the version of the defendants, it seems that the plaintiffs have a prima facie case to go for trial. Thereafter, I have gone through all materials on record till now and have carefully perused the documents which are in the case record. Admittedly, there is a decree in favor of the defendant number 1 by title execution number 30 of 2017 of the Court of the Learned Civil Judge number 1 Kachar Silchar. Such decree is in favor of the defendant number 1, and the present plaintiffs pray for temporary injunction restraining the defendants from proceeding with the execution case. Hence, it reveals at the cornerstone that temporary injunction is primarily sought for against the execution proceeding of the other case as stated above. However, it needs to be noted that all questions arising between the parties to a suit in which the decree was passed shall be determined by the court executing the decree. The materials on record further reveal that pursuant to the decree passed by the Court of Learned Civil Judge number 1 Kachar Silchar, the registered deed of sale was executed in favor of the opposite party number 1, and the same was duly registered. The opposite party number 1 again pleads that he is the bona fide purchaser of the decretal land. Accordingly, on the specific plea of the plaintiffs that the other decree is obtained by fraud, it seems that without determination of such prime issue at which the parties are at variance in the main suit, any order of injunction against the present opposite party number 1 in whose favor the decree was passed may cause irreparable loss and damage to such opposite party. Under such premise, the balance of inconvenience may also tilt towards the opposite parties. The issue of fraud, if any, are matters to be decided in the main suit. Moreover, the other execution case is also pending, and hence any issue regarding the execution, discharge, and satisfaction of decree shall be determined by the said other court. Consequently, till disposal of such issues, temporary injunction is not warranted in the present circumstances of the case. Although the court cannot pass any judgment in the present stage of the case as regards the claims of the plaintiffs regarding the declaration as prayed for in the main suit, yet on the basis of the discussions made above, it apparently seems that there is no urgencies as such in the claim of the petitioners in the present stage of the suit, which necessitates grant of temporary injunction. The court needn't go deep into the matter, into the merit of the case in present stage of the case to decide the matter of temporary injunction. Consequently, I am of the considered opinion that without
Yes, what are your grounds?
ground, your lordship,
You have to wonder what are the grounds.
the ground, your lordship, is that prima facie the land is an Ejmali
You need to do what? Wonder.
order. I understand your lordship is hinting towards order 21 rule 97. That
No, wonder. Wonder versus Entox.
Wonder versus Entox is there, your
You have
lordship.
to wonder, to look into the grounds. You do not find any grounds.
The Wonder versus Entox though says that once if an order has been passed by the trial court, it needn't be traversed into by an appellate court.
See, these are
Another-
matters of discretion which have been exercised prima facie, not prima facie, explicitly by application of mind. Unless you show something gross perversity,
To your
We are not
lordship, but
supposed
2-3
to-
points could have been or ought to have been.
for us, for a revisional court, very difficult. Even infirmity of major, minor, I think we are not required. And this has been upheld by the appellate court.
Upheld by the appellate court through your lordship. However, the
Not a
land
fit
is
case. You
land is
save your energy for some other case.
lordship will just kindly allow me to place just 2 grounds. Thereafter, I will rest my case.
Look, tell us, hurriedly. We have.
One, your lordship, is that the suit land is Ejmali in nature. Since the suit land is
We were not going into the merit.
very well, your lordship.
You can address us on the exercise of discretion. Was there any gross illegality committed? Was there any perversity committed?
The appellate court,
In
your
fact,
lordship,
the court has held that prima facie there is a case
prima
to
facie,
go for adjudication.
that is
But there is a decree which needs to be adjudicated whether the decree is by fraud or not. For that, should the entire execution be put to stay?
the balance of convenience, your lordship, in the sense it ought to have
Everything will
been-
be dependent on outcome of the suit.
it ought to at least ought to have been looked into by the executing court. The fact that
Okay,
written
okay,
statement-
we have heard the intent of the Senate Council for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging an order dated 12/5/2023 passed with the learned additional district judge FTC bracket Kachar in Miss Appeal number 3 of 2020, whereby the appeal has been dismissed and the order dated 11/12/2019 passed by the learned civil judge number 2 in Miss Case 4 of 2019 arising out of title suit number vote number 4. Title suit and Miss Case both are 4.
4, your lordship,
Both.
4 of 2019.
Arising out of title suit number 4 of 2019 has been affirmed full stop, by the initial order dated 11/12/2019, the prayer for temporary intensive has been rejected, which has been affirmed by the learned appellate court. Full stop, para. Shri Chaudhary and Chaudhary, the learned counsel for the petitioner, has submitted that the land in question is an Asmali land, and it appears that the present defendant number 1 was equipped with a decree and sealed it of September 2018, which the present petitioners were not aware of at all. Full stop, para. He has further submitted that the earlier litigation was between the respondent numbers 1 and 2, was between the respondent number 1 and respondent number 2,
Referendum 1 and 2.
in which the present petitioners were neither made parties nor they were made aware of such proceedings. Full stop. It is also submitted that both the decree and the consequent statement executed through the court appears to be vitiated by fraud.
Yes, your lordship, and this fact is evident.
Fraud. Full stop. Para. The learned counsel submits that so an ad interim injunction was initially granted, the same was vacated, and the injunction and the prayer for injunction, temporary injunction, was rejected, which has been upheld by the appellate court. That the exercise of powers by a trial court while deciding an application for injunction is necessarily a discretionary power, which is required to be exercised by judicious by taking into account the relevant facts and circumstances. It is a settled position of law that until such discretion appears to have been exercised in gross illegality or there is perversity in the order, a revisional court shall not, it will not be proper for a revisional court to interfere with such order. In the instant case, the order dated 11/12/2019, while rejecting the prayer for temporary injunction, has made discussions which cannot be said to be without any reason. In fact, this court has noticed that it has been held that there is a prima facie case made out by the plaintiff to go for trial. However, it has further been held that there is a decree in favor of the defendant in the title execution case, and the temporary injunction has been paid for to restrain the defendant from proceeding with the same execution case. Full stop. It is on the ground of balance of convenience that the order of injunction has been rejected, that the prayer for injunction has been rejected. Full stop. Para. The appellate court by the judgment
It is
dated 12 May 2023 has scrutinized, has looked into the state observation and has concurred with the state conclusion. Para. It is a settled law that the powers and jurisdiction of a revisional court is circumscribed and would be available only on certain conditions, which are broadly as exercise of powers without jurisdiction, comma, taking account of materials which are irrelevant and extraneous, and not taking into account relevant and German material before the court. Full stop. The aforesaid conditions which do not appear to be present in the instant case. Under those para, we cite two cases, Wonder and Talks and Ramdev Food. Under those factors, comma, the instant case.
Hello. So my learned friend advanced arguments, my lord.
He has argued well.
I have, my lord,
There is no scope of improvement.
at a certain point, my learned friend has.
No, he has argued well. We are not going to change our conclusion.
But only one point I like to, Lordship permits me.
No, not permitted.
One citation.
No,
I
not
like.
permitted. Not permitted. In a better case, we'll permit. We'll permit him, not to you. Not in this case. Yes, next.
Obliged.
Mr. Biswas, what is this?
My lord, the matter relates to the decline and denying to submit the written statement, my lord. I am the wife, my lord. The matter was pending for counseling for months together. But only one chance I want to file, my lord. Otherwise,
When was the suit instituted?
so it was instituted, my lord. I take your lordship to 2021, my lord.
21 till 23 have not filed your.
No, my lord, matter was pending, my lord, for counseling.
Does it mean that there will be automatic stay, or you are not required to file WS?
No, my lord, I take your lordship. The matter has come from the counseling only on.
You
Last
show,
occasion.
you show us the law or provisions of law, which
But,
says that when a matter is at the counseling stage, you are not required to file.
But on that matter, it is not there, but the judgment, your lordship is very much aware of that. It is my right, my lord, kindly. Supreme Court has held that right may
No,
be given.
these are right law, that these are directory and not mandatory, but we are not going into those facts. We are going to your contact 2 years,
But I am a wife, my lord. The husband has filed a divorce suit, my lord. I must give an opportunity to file my reply, my lord.
Kailas Nanku was cited two decades back, not now.
This judgment 22, my lord.
No, we are on Kailas Nanku, Salembar.
Yes, that is the old case, my
These
lord.
are 2 decades. We are following the directory law, but these are still, this has become very old now. What is your conduct?
So my
Only by
contract,
saying that these are directory, you will wait till.
my lord, this lay lady, my lord, layman, my lord, depend upon in the family code, no lawyer is also allowed, my lord. She is not very much aware, my lord, of these things.
You are advising her, so where is the problem?
Now I have come here, my lord. My last occasion, my lord,
What is the stage?
my lord, the order dated kindly page 22, my lord.
What is the stage now?
Now it is fixed for evidence, my lord. That is date is, my lord. Before that, I will file, my lord. Next first time, my lord.
No, 13/7 was the date. What happened on 13/7?
We have to, they have taken adjournment by a
When
husband.
is the next date?
That record is not with me, my lord.
It was
My lord.
heard 3 SCBs for learned counsel for the petition, who has filed this petition. under Article 227 of the Constitution of India. Being agreed by an order dated 21/6/2023, passed by the learned family judge, learned principal judge, family court number 2, Roman 2, Kamrup M. CFC within bracket C, number 1092 of 2021. Full stop. By the said order, it is submitted that the scope of filing written statement by the petitioner has been curtailed and the next date has been fixed for evidence. The business the learned counsel submits that in the proceeding before the learned family court, which is for divorce, the petitioner is the wife, and since the matter was at the stage of conciliation for a long period of time, the petitioner was under the bona fide belief and impression that there was no immediate requirement to file written statement. Sarah. And he further submits that if the petitioner is denied of an opportunity to contest the case, irreparable loss and injury would be suffered by her. The paration notice returnable on. What is the next date?
13/8 for evidence matter. But before that, I'll file matter.
Without hearing, 13 returnable on. We'll have it on 13/8 is a Sunday. How can it?
I'm sorry.
No, that date fixed by the family court.
Yes, yes.
What is the date? Are you aware?
To me, to my information, it is either Friday or Saturday. Madam.
Which date?
August 12 or 12, I think.
12 is also non-working Saturday. Returnable on 23rd of August. That step be taken for service of notice upon the respondent by reset post to daily. For step by Monday. Can you take the stay?
His husband will not accept. I cannot.
The parties are also given liberty to inform about the next date to the respondent or his counsel on the next date fixed by the learned family court. The learned counsel prays for an interim order. Considering the facts and circumstances, this court, while not inclined to pass a blanket interim order, it is provided that till the returnable date, the learned court shall keep the proceedings of assistance in abeyance. An endeavor shall be made to dispose of this matter on the returnable date on appearance of opposite party, as the suit was instituted in the year 2021. Take step.
I'll take.
Just you take this back.
If the issue has been second lost, series of cases has been disposed of.
That's why they are not interested. Issue is whether the under a public premises eviction act, whether further evidence can be allowed or not under order 41 27.
What has been said?
That has been rejected, Lordship. The appellate court rejected, they came to the CRP.
Okay, none appears for the petitioner on call. So, on the other hand, Shri B. Chakraborty, learned CGC, submit that the issue involved has been settled and perhaps for this reason, there is no representation on behalf of the full stop para. Be that as it may, let a further opportunity be granted. Directing listing of this matter on Wednesday next. It is however made clear that in case of further non-appearance on behalf of the petition, this court would be constrained to pass appropriate order. Present it on Wednesday. Dispose.
May it pleases your lordship. Lordship, may the matter may be passed over for a day, your lordship, as my senior is not well.
Mr. Bhuya is not well.
Yes, your lordship.
My lord, on Monday next, if possible.
Monday is not, Wednesday.
Yes.
Part 3, B. Bora, Learned Counsel for the petition. However, this court has been informed that the RK Bhuya, Learned Counsel for the respondent is unwell. Full stop. The Bora, Learned Counsel, however, expresses urgency. Full stop. This on Wednesday next. But it,
Obliged.
May it please your lordship.
Yes.
Your lordship. Impugned order is at page 33.
33.
Page 33 is the impugned order.
Hmm.
Whereby my lord, my application for adjournment, seeking adjournment for filing WS has been closed. And that was the second occasion, lordship. Before that, one opportunity was given 5/4, and counting that day as 90 days statutory period, my application has been rejected.
Why didn't you file?
Lordship.
Why didn't you file your written statement in time?
Yes, lordship, there was certain inconvenience on that day, and that is why application has been filed seeking adjournment for another date and stating that due to unavoidable circumstances. So my lord, my case is also covered.
But 90 days is not a.
It's a
pretty reasonable time, 90 days.
yeah,
And 90 days is the
true,
extended time. You have to file it in
that is
1 month.
That is true, lordship. In the meantime, there was a multiple number of cases pending here and there, and petitioner had to look at each and every case. And lordship, so not one opportunity may given, and that is it is not direct lordship, mandatory lordship. Looking into that.
Those are
aspect.
those are all right, directory mandatory. But what is your conduct?
My
Well,
conduct
how are
is,
you
lordship,
prevented by
yes, my conduct is, lordship, only one occasion twice on 5/4 after counseling, lordship, on 5/4 first date was given for filing
Is your
WS.
written statement ready?
Yes, by tomorrow it will be ready, lordship. I can file anytime after
Today you will
tomorrow.
prepare.
Yes, lordship.
Today you will prepare. If you can prepare a written statement within 1 day, what took you 90 days to present it before the court?
It is halfly prepared, lordship. It is almost done.
After prepared now in the court,
No, no,
after
lordship.
asking the question.
No, no, lordship, because it was before, lordship. It was before.
When is the next date?
Yes, 7/8 is the next date, lordship, for issue and documents.
I heard MSP from Learned Counsel. You are the wife,
Yes, and the white lordship.
Learned Counsel for the petitioner who has filed this petition under. What is this? What is this section 227? Madam,
Lordship,
what is this section 227? In the cost side,
yes, Lordship.
what is section 227?
Lordship, it is the power of the court,
Section
Yes.
227.
not section under. Little mistake is there, Lordship.
Take care of this.
Lordship.
We don't like this kind of mistake.
Sorry.
Somebody may like, but we do not like.
Oh,
Correct this.
yes,
We'll have it on Wednesday.
Lordship.
We'll have it on Wednesday.
Yes, Lordship, will continue. Lordship, I may be allowed to correct by hand.
Correct it. We are not taking up today. Yes, next.
May I please, your lordship?
Then what is it?
My lord, what has happened in this case? My lord, the plaintiff and the defendant number 1 to 4, my lord. They are, my lord, brothers, my lord. The predecessor of the defendant number 1 to 4, my lord. Here the petitioners, my lord. Defendant in the suit.
Petitioners are the defendant.
Petitioners are the defendant in the suit, my lord, in defendant number 1 to 7. My lord, 1 to 4 is the, my lord, legal heir of Subroto Das. My lord, Subroto Das and the plaintiff, my lord, Johanto Das, they are brothers, own brothers, my lord. They purchased a plot of land measuring 2 biga, my lord, 8 katha, 8 chota, in the year 1980. And thereafter, my lord, they possessing the land, my lord, with the specific boundary. My lord, thereafter land has been partitioned by way
What
of,
is the order you're agreed to?
my lord, thereafter the defendant contested the suit. We purchased
Suit was for what? Suit for what?
suit for preferential right, my lord. One brother filed the suit, my lord, Johanto Das, against the legal heir of other brothers, and my lord, we purchased from the legal heirs of the other brothers, my lord, Subroto Das. Now, my lord, he says that declaration, he prays for a declaration of my lord, the preferential right, and for direction of to the defendants to execute a sale deed. Now, we filed a written statement. We said that the land has been partitioned and by way of registered partition deed with specific boundaries, and they are, my lord, respectively possessing the land. My lord, the defendant number 7 to 9, my lord, they have purchased the land from us. That is defendant number, my lord, the petitioners here and defendant in the suit, my lord, 1 to 4. My lord, we have filed our written statement, laid evidences. After conclusion of evidence, the suit has been dismissed. Against that, they prefer appeal. My lord, at the appellate stage, the my lord, respondent, my lord, here and the plaintiff in the suit, they filed an application, my lord, for under section 75 of my lord, the CPC, praying for local inspection of the suit land, my lord.
In the appellate stage.
In the appellate court, my lord. Now, whether, my lord, the point here is appellate court has jurisdiction, my lord, to pass an order for local inspection of the, my lord, suit land, because your lordship aware, my lord, AIR 1971, my lord, Assam and Nagaland, your lordship aware, my lord, the local inspection is made to appreciate the evidence, not to furnish the evidence, my lord. Now, the evidence has already been done in the trial stage.
Is there any application for evidence by the appellate court under 4127?
No,
That has not come as yet.
that has not come.
But is it barred in law that the appellate court cannot have an inspection done?
There is no scope, my lord, in CPC. that appellate court, because court is to, my lord, for local inspection is to appreciate the evidence. The evidence part is already over, my lord, at the trial stage.
No, the appreciation can be done by the appellate court also. Appeal is nothing but an extension.
No, that's true, my lord. But for appreciation of evidence, that evidence has been part, my lord, learned trial court, my lord, in its judgment.
Let us see the provisions of 75.
75, lordship, kindly see. Wait a minute, my dear. My lord, section 75,
Yes.
my lord.
Yes.
Has your lordship got it?
Yes,
Yes. My lord, power of the court to issue commission.
yes.
Subject to the conditions and limitations may be prescribed.
Hmm.
The court may issue a commission to examine a person, any person, to make local investigation, to examine or adjust account, to make petition, to hold, my lord, this is not to perform ministerial, my lord. But this is, my lord, as I have pointed out, my lord, court can, my lord, pass an order for issue of a local investigation of the suit land, my lord, for the purpose of, my lord, to appreciate the evidence on record.
Hmm.
Now, my lord, the evidence has already been done or laid by the parties at the stage of trial. My lord, appellate court cannot take, my lord, can take evidence, my lord, under order 41 rule 27. But they have not filed any application for filing, my lord, additional evidence. And to appreciate that additional evidence, my lord, local inspection is necessary. That is not their case. They simply file an application under section 75, my lord, for
Can you
local.
restrict the meaning of the court to only a trial court?
My lord,
The expression court used
Yes.
in 75.
my lord.
Can you restrict it to only to mean the trial court?
My lord, it's not said that appellate court, my lord. Court says
Court,
Court.
the expression is court.
court, my lord. That's true.
Court is not the trial court alone.
Yes, that's
Has
true. but
court has not been defined in the court. Does
Yes.
the court defines court? It's not been defined.
No, it's not defined, my lord.
So-
Court means it may be appellate court, but appellate court, my lord, to determine or to appreciate the evidence on record. The very purpose of local inspection, my lord, is to appreciate the evidence. Now, whether the court, my lord, appreciate an evidence which is already on record, my lord, appreciated by the learned trial court,
Where is the decision you're trying to retire?
my lord. AIR 1971,
71.
Assam and Nagaland 127, my lord.
Name,
My lord, Assam and Nagaland, High
name,
Court.
name.
Name, my lord, Mohindra Kumar Rai versus Paresh Chandra Dev. It is division bench judgment, my lord.
Let us take.
My lord, paragraph 4, my lord. আমাদের কপিটা দাও। আমাদের কপিটা চাই। Paragraph 4, my lord. May I read it, my lord? By the impugned order, the learned Munshi purported to exercise his power under order 18, rule 18 of the Code of Civil Procedure. Since the measurement of land was done in presence of the plaintiff and his lawyer, it is held that the Munshi that he cannot raise any objection to the measurement. The learned Munshi
This is
object.
not applicable.
My lord,
This is on a
here
different
it is.
context.
Here it is says, my lord, the very purpose of, my lord.
There is no dispute with your proposition.
Yes,
What is the purpose of an inspection?
yes.
Local inspection. But
Now, my lord,
that
position.
power
Court,
cannot be exercised by an appellate court. You have to show us something.
my lord, power, my lord, it is not, my lord, specifically stated in the, my lord, in CPC.
Power
Then
has been
appellate-
given to a court.
My lord, power is given to a court, but to appreciate evidence, my lord. My point is that, but you, my lord,
Or 3 decades then Learned Counsel for the petitioners who have filed this petition under Article 227 of the Constitution of India against an order dated 30/5/2023 passed by the London Additional District Judge Hailakandi in title appeal number 5 of 2023 by the state order, the London Appellate Court has appointed a commissioner to make a local inspection to ascertain the position of the parties over this woodland. The petitioners are the defendant numbers 1 to 7
My lord.
in the connected title suit, which the title suit number 12 of 2011
Yes, my lord.
filed in the court of the London Civil Judge Hailakandi. It is the case of the petitioners that the state suit was dismissed after after appreciation of evidence, whereafter the plaintiff had referred the aforesaid appeal, in which the impugned order dated
23, 35,
2023 has been passed. Then the learned counsel for the petitioners, by referring to section 75 of the Code of Civil Procedure, has submitted that such powers are to be exercised only for appreciation of the evidence and cannot be, and such appreciation of evidence, and in the instant case, since the evidence were already adduced by the parties, which were closed and duly appreciated, there is no further scope of exercise of such powers under section 75 of the code COT, that to by an appellate court. This happens that powers of the present nature are to be exercised at the first stage itself and cannot be extended to an appellate stage, as question of position would have existed at the time of filing of the suit itself. This court has given its NCS thought to be recorded. In support of its submission, we then the Learned Counsel has relied upon a case of the Honorable Division Bench of the High Court, reported AIR 971, Assam and Nagaland 127, within brackets, uninterrupted small right. The specific reference has been made to paragraph 4
My lord.
of the state judgment. This court has given its anxious thought to the submissions advanced. for the sake of convenience, section 75 is extracted here in below. Section 75 para. The reading of the aforesaid provision makes it clear that such powers are conferred to a court. Full stop. There is no distinction between a trial court or an appellate court, and therefore it cannot be held that an appellate court shall not have the aforesaid power to issue commission. Full stop. Para. When it comes to Christian has strenuously argued that the purpose to issue commission is only to appreciate the evidence. This court is of the view that the state submission will not come to the aid of the petitioner, as the first appellate court has equal power to appreciate the evidence of record, and for better appreciation, issuing a commission may not be held to be a step which is against the objective of the act, and would rather be a step toward proper dispensation of justice. This court has also gone through case law cited. The state case which has been relied upon is not in connection with exercise of power under section 75 by an appellate court, and therefore would not come to the aid of the petitioner. It is also subtle. It is also a subtle law that powers of revision are to be exercised in a circumscribed manner and only under certain limited conditions, which may be available under the aforesaid facts and circumstances. This court is of the considered opinion that the present case would not come within the ambit of such ambit for exercise of powers of revision, and according to the petition. Yes.
But actually, in this case, the registry, not to be recorded kindly, I am telling as per their request. Registry has requested me that kindly take a date because the file is found missing.
Which file?
Some file including Wakalatnama that is found missing from the registry. So I have been told that kindly bring the Wakalatnama fresh, and then case may be listed in the next week. I have already called the
Wakalatnama, who's Wakalatnama?
petitioners.
Petitioner as well as the respondents are there.
Doesn't matter, you are there, your names are recorded. Those technicalities will not go.
The registry has requested me. That's why I'm.
Registry is requested, but we are not having. Registry will not have any difficulty if we take up the case. Is there any difficulty for your part to advance?
No, from my part now, no difficulty at all.
Yes.
Perhaps no one also he has been also told. So
Doesn't matter if that file is not there. How does it matter to us? If you want some time, we can transfer. It's not an issue, but that's not the purpose.
Can continue with the case, not it?
Okay, we'll have it on Wednesday.
witness.
We'll not say anything, we'll say on your prayer. The learned council jointly submit that the matter may be taken up on any other date. Please to release this case on Wednesday night. Next day, we'll have it, in
Yes.
spite of the fact that whether.
If there is any adverse against the registry, then we have no objection. They have actually
No,
repeatedly.
even if it doesn't come, we'll not wait for it. We'll go ahead. Next week.
But without observing anything against.
We are
the-
not observing, we do not even know.
Yes, obliged.
It's to who take care. I put- Yes.
Please, your lordship.
Yes.
My lord, here I am the borrower, my lord, and a mortgage of a particular suit property, my lord. And there was we have challenged the surface proceeding, my lord, in the court below, the debt recovery tribunal, my lord. My lord, in course of certain proceedings, my lord, lordship will see at page 39. At page 39, my lord, this honorable court yes, my lord. It said, my lord, in the last second last paragraph, further, whatever plea the review petitioner is seeking to raise before the court, page 139, my lord.
130.
139, my lord. Okay,
139.
yes, my lord. My lord will find that the second last paragraph, further, whatever plea the review petitioner is seeking to raise before this court can easily be raised before the learned DRT, where the review petitioner, being the borrower, is also a party. So, my lord, here, just crux of the matter is this, my lord. My property due to default was put into auction sale. Auction sale was confirmed, my lord, on 1/9/2021. And the, my lord, prospective auction purchaser, my lord, he paid 25,000 of the 25% of the auction bill. So, my lord, now it is admitted, my lord, that another 15 days he has to complete the entire auction process. So another 75% should have been paid within 16/9. That is on record, my lord. They have admitted in their repetition. So 16/9 was the date. And my lord, the rule says, my lord, if there has to be any extension after 15 days, that has to be in written by the bank. And the permission has to be given to the auction purchaser to extend another 75 days for the auction bill.
Another 75.
75 days, my lord. It says total period of 90 days. That means, my lord, 15 days plus 75 days. So, my lord, facts of the matter is this. On 12/9, yes, that our petitioner before lordship on certain allegations, my lord, was put to judicial custody on 12/9/2021. And my lord, that there has been, my lord, plea of the bank that on 14/9 there was a vacation notice, which we deny, my lord. Because at that point of time I was in custody, I am not aware of that particular vacation notice. Now, my lord, on that ground, my lord, since there this strength of this honorable court's order, we filed two interlocutory applications before the court below. One was for impleading the auction purchaser, which was done, my lord, on the very day implement was done. And another, my lord, we have filed to furnish us, my lord, all the copies in regard to the communication with the auction purchaser, because we want to know, my lord, what has happened after 16/9, whether there was any written application, my lord, or written permission by the bank. So we approached the court below by way of IA to furnish all those documents. But those were denied on the ground that this may not be required because third parties document you do not require, and it would amount to putting it into in public. So, my lord, we are agreed on that part. We just pray before a short prayer, my lord. We need only the documents, whether communications and all those documents, my lord, along with the auction procedure.
Why do you need?
My lord, because 16.9, the bank said that you have to pay or your auction would go. That is, my lord, I would say from the writ petition at page, lords will find it
16.9 what?
16.9, 2021.
21.
To 2021. My lord would find this at page number 101.
Now what is the stage now?
My lord, stage is for final hearing.
Not of the property.
Property is that although sale was confirmed, it is not finalized because to our information, final amount is not paid because there is a stay from in the court below for enter proceeding, my lord. So they say, my lord, since there is a stay, so they cannot pay the final.
Stay by which court?
By the DRT, learned DRT, my lord.
Stay is operating.
Stay is operating. And my lord, the next and the final date is given on 1st of August.
Mr. Dr. For
the bank.
bank. Who are the contesting respondents here?
Here, my lord, respondent would be the bank and the auction purchaser, but he is a private respondent, so probably.
See, normally DRT as service proceedings would be very.
That is
our approach to be go very slow. But here you say that stay is already operating by an order by the DRT.
Yeah.
He has raised the issue of rejection of his application by which he had asked for copies.
Yeah.
Right.
That we can examine, we can issue notice.
No, Lordship, here I just have one point out here. First and foremost, your Lordship, there is an alternative remedy. Section 18 of surface here. Very clear.
Perfect. Yeah. Yes.
Lordship, section 18. May I read?
Please.
Section 18, clause 1. Any person aggrieved by any order made by the Debt Recovery Tribunal under section 17 may prefer an appeal along with such fee as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order of Debt Recovery Tribunal. It's clear. And I'm citing two judgments, Lordship, and bear with me. Two judgment, latest judgment of the Supreme Court, both the case, where it has been held that High Court should not interfere when there is an alternative specific on surface here.
Which are these two cases?
So I've got it from online. 203 Live Lord SC to 320.
These are recent.
Recent. And in one of the
same, I think.
Your Lordship.
Both are the same.
So same. In one case, they have decided at 227, and in 227 in as a whole. But same, both are same. Spirit is same.
No, it's the same judgment.
Yes, sir. I'm sorry, Lordship. I'm sorry. Both again. Same.
The same judgment.
Same. Sorry.
You think giving two copies will mean two judgments?
Sorry. And secondly, Lordship,
Yes.
matter, and the entire
Which
matter
paragraph?
is
Which paragraph?
Lordship, page 14, para 9.
This copy, Lord. I've marked the Lordship.
How does it start?
It starts from page 13,
How does it
State
start?
Bank of Travancore versus Matthew Casey. Page 13. I marked it, Lordship, for you.
Satyavati Tandon has been referred or not?
Yes.
Referred.
Yes.
Page paragraph 14.
Page 14, paragraph, internal paragraph 9.
Page 14.
Page 14.
Yes.
Yes. Even prior to the Surface Act, considering the alternative remedy available under the DRT Act, it is held in Punjab National Bank versus OC Krishnan, 2016 SCC 569,
Yeah.
that this is so and so. The act has been enacted in a view to provide a special procedure for recovery of debt due to the bank and the financial institutions.
This is the quotation from Muthi Krishnan.
Yes.
You let us see what in this order, what has been said.
In Satyavati tender.
No. 9 has only quoted O.C. Krishnan in paragraph 6 of O.C. Krishnan.
Yes.
Isn't it? Where is the findings of this in this case?
Finding.
My lord, may I point out one thing, my lord? My lord, for
Yes.
this section 17, my lord, deals with the provisions laid down in regard to section 13(4).
No,
My lord.
it is referring to 18.
Yes, my lord, but
Section 18.
yes.
That is here.
18.
Yes, where are the findings in this?
Page 18, paragraph 18, last page.
150.
Yes.
And your lordship, they have been enjoying the stay since 24/11/2021.
No, see, we are not passing any order of stay. That is up to you, how to you take steps for vacating that order.
The matter, entire essay had been fixed for hearing, final hearing on Tuesday, August 1.
Tuesday, this Tuesday.
Yes,
You go ahead with the hearing. We are just issuing notice here. We are not passing any order.
because the auction parties are being suffering here. That is also
We'll
a
just
problem.
adjudicate whether the prayer to supply him with the copies,
Yes.
rejection, whether that's proper or not.
My lord, may I pray only this much, my lord? My lord, since we are onto it, my lord, there is no other option but to go for hearing. But on Tuesday, my lord, why I'm saying that, my lord, once a decision is taken there, probably my right of that.
We're not allowed to delay the proceedings by taking.
My lord, can it be this way, my lord? Only those documents may be furnished to us, my lord. It can be closed also.
Without hearing, how can we?
Because, my lord, otherwise bank is here, my lord.
Bank is here, there is another party.
But that party, my lord, may not be, my lord.
These auction, just I'm interviewing, the documents they are seeking is the auction purchaser who had participated in an auction, in an open bid. And we cannot provide them those documents. Otherwise, it will open a floodgates.
My lord, only one
is not our,
one
because he is no way connected with those
I am the owner of the mortgage property, my lord.
because they
And
have
my
failed
lord-
to pay up the money and they have waived the right as per section 13(8).
May I pray, my lord, only one document would also otherwise suffice. If there is any written permission in terms of,
Without hearing, we cannot.
yes, my lord.
We cannot pass orders of furnishing of documents.
My lord, can it be this, my lord? I will pray for an adjournment. That may be.
No, not at all. Not at all. That is not the spirit. Not at all. Our T.H. Hazarika, learned counsel for the petitioners who has filed this application under Article 227 of the Constitution of India against an order dated 1/6/2023 passed by the learned DRT 1 in I 247 of 2023 arising out of NDN number 587 of 2021 full stop, by the state order, comma, the prayer for furnishing documents has been rejected.
Yes.
Has been rejected.
Has it rejected? Full stop. Sarah, it is the case of the petitioner that they were the borrowers plus mortgagors in which are proceeding under the Surface Act, full name sector, please select, hearing of surface, was initiated. There was earlier proceedings in this court in which a matter was remanded, allowing the petitioners to raise the issues before the tribunal. Whereafter, comma, as per the Hazarika, comma, two interlocutory applications were filed. Full stop. In the first application, comma, a prayer has been made to implement the auction purchases,
That has been done.
That has been done.
which has been allowed, and by the second petition, which has been registered as IA number 247 of 2023, comma, the prayer for furnishing of documents has been rejected. Whereas the Hazarika, the learned council, submits that unless and until the documents are handed over to him, comma, he would suffer prejudice in defending himself in the final hearing, which has been completed on 2nd of August.
First of August.
1st of August, 2026. Per contra, comma, as Dr. Subrukut, council appearing for the respondent number 1 bank, respondent 1 Punjab National Bank, has submitted that the retribution itself is not maintainable as alternative remedy in the form of section 18 of the Surface Act is available. He further submits that that the final hearing is fixed on 1st of August 2026, and at this stage, comma, no orders may be passed by this court as the initial proceeding was initiated as the original proceedings were initiated in the year 2021. Issue notice returnable by 4 weeks, by 3 weeks. As Dr. Council has accepted notice on behalf of respondent number 1. Let an extra copy be served upon him by Monday. Full stop. Let steps be taken. I think 1 and 2.
Yes, 1 and 2.
Authorized officer.
Yes, 1 and 2.
1 and
I have received it today.
let's
We have.
extra copy. That steps be taken for service of notice upon respondent number 3 by registered post steps by Monday. The question of maintenance, however, is kept open to be decided on.
Maybe just my prayer. The small that the proceeding should go on,
We are not seeing
but the tribunal may take it that way.
why. Where is there any order of stay? Rather, we have said that maintainability is kept open.
Yes.
Diplomat.
My lord, in that strength of section 18, we may file an application, my lord, that may be kept open, my lord. Yes,
That is already open.
yes. Obliged, my lord.
One, you can take it back, Mr. Rathore. One decision is trying to break. You to take it. Okay, this will take some time. So others, at least first up, there is no scope of any other matter. Maybe by 2:30.
Yes, sir.
Please, sir.
Also, petitioner also, she is working presently as an assistant teacher in Malawali High Secondary School. What happened in this case, Lordship? In 2000.
One second. Presently what?
As assistant teacher in Malawali High Secondary School, Jorhat.
Malawali.
Malawali. She is a senior teacher, and on 29/7/2011, she was appointed as in-charge principal of the same school. But her state appointment was
You are removed on 8/9.
yes,
the in-charge
8/9. Yes.
8/9.
8/9
From
was
the
I was
in-charge
removed,
arrangement.
yes. Then I challenged her the appointment of respondent number 5 in WPC number 4797. WPC number also 4797 of 2011.
You should challenge your removal.
Removal, and also subsequently I have filed another writ petition, her continuation as in-charge principal. Because in the earlier writ petition, there is a direction to hold the regular selection. That is in
No,
respect
no, one
of
second, one second. You were removed on 8/9, isn't it?
8/9, what's it?
11. Thereafter. Now, what about the initial 4836 of 11?
Or
WPC 4836 of 11. If the court has interfered on 21/3/2012 because they had taken a stand that the removal was for because there was a notification.
Yes.
The subject teacher would have a better claim than an assistant teacher.
Yes.
So removal was justified.
Yes.
And this notification, however, was
withdrawn.
No, it was interfered by this court.
Yes, in Tina and the Dottov's case, Lordship.
Is it 4836?
Lordship, yes. Yes, 4836, Lordship. Yes, I have the judgment. Lordship.
Yes. Thereafter, you filed 4797.
Like for continuation of our in-charge principal, because they are the direction to hold a regular selection. 4836, Lordship, I have the judgment.
Okay. 4836 by another party.
By
Then you filed 47.
Several petitions were filed at that point of time, challenging that same notification, since subject teachers were given privilege over the assistant teachers. And at that point of time, Justice B.K. Sharma had passed that judgment. And that notification was withdrawn. But they continued, but they did not interfere with their appointment, and she continued. Subsequently, Lordship, in 2017, Lordship, that the regular selection process took place, Lordship. In 2016 itself, and that respondent number 5, since she did not have a B.Ed degree, she was out from the race, and she became the member secretary of the selection committee. So my first ground is, Lordship, is with regard to biasness. Since I had filed 2 writ petitions against her, and she became the member.
Now, who was selected?
Respondent number 6 was selected. Respondent number 5 did not have a B.Ed degree, so she could not participate in the selection for regular principal. And Lordship, she became the member secretary of the selection committee. And Lordship, in this respect, Lordship, Badrinath's case, Lordship is ever, Lordship, only 3 small paragraph, Lordship.
75.
Yes,
Paragraph 75.
paragraph 75, paragraph 75, 78, and 79, Lordship. May I place the judgment, Lordship?
Yes, yes. Now you are challenging that BA degree of respondent number 5.
Respondent number 6. Respondent number 5, Lordship, she was, our dispute was with regard to incest principle. Now, when the regular selection took place, she was out of the race because she did not have a B.Ed degree.
This respondent number 6 has got his BA from
Deomona B.Ed college, which is 271 kilometers as per Google map. And that is a
271. This is R6.
R6.
Thereafter,
Now, Lords, with regard to Lordship, leadership skill, with regard to leadership skill, Lordship, I have stated that since I am assistant teacher, the HSLC results should be taken into consideration. And since he is teaching economics, the subject concern should be taken into consideration. Now they have come up with an affidavit saying that the overall results should be taken into consideration. Even in that case, Lordship, both are given same numbers.
Yes.
Same marks, Lordship. In the category of administrative ability, Lordship, the petitioner has produced number of certificates as a resource person. She was appointed as a resource person and as a master trainer, and she has been given national certificate also. I have brought those things on record.
Was it
But
before
the
the committee also?
Yes, I produced before the committee also. And the respondent number 6 could not produce any such significant document, Lordship. In that case, in administrative ability also, Lordship, both are given 3 out of 5.
ACRC gets
Then ACR and integrity, Lordship, that your Lordship has
you
already
get 3, she gets 4.
She gets 4, Lordship, I have been given 3, and your Lordship has perished the record, and your Lordship has recorded in order dated 28, Lordship, on 9/1/2019, Lordship.
You
Nine-
say that you should have got 3.61
No,
in leadership.
yes,
As per you should have got 3.61.
3.6.
And she should have got
She should have got
3.27.
3.27.
3.23.
3.27, yes.
2.3.
3.23, Lordship.
And integrity, you are given 3.
And integrity, Lordship, integrity and ACR, respondent number 6 has been given 4, I have been given 3.
And it was given by the president, not by the IS.
And not by the president, and it should be by the inspector of schools. And that your Lordship has already recorded and produced the ACR and integrity on 9/1/2019, Lordship, it has been recorded.
9.1 or 19.1?
Lordship, I may be wrong, Lordship, I have noted down as 9/1. That judgment is order is there, Lordship. Your Lordship's order is there. It is
9.1.
9/1. And also in respect of seniority, the respondent number 6 is 5 years junior to me, Lordship, in service.
What are your, if you sum up your challenge, grounds of
Yes.
challenge, you are saying that she doesn't have a valid B.Ed degree.
Yes.
Number 1. There is a element of bias
Bias.
as respondent number 5,
Okay.
with whom you were all along having litigation,
Litigation
is in the panel.
panel.
And how is the respondent number 5 related to respondent number 6?
Because she could easily influence the other members of the selection committee.
No.
There are 3 members.
Is she related to respondent number 6, the selected candidate? The bias are you are projecting with you, not with regard to the selected candidate.
Not with regard to the selected candidate.
You have been given less marks,
I have been given less.
deprive you.
Yes, Lord.
And you say that, so far as STRs are concerned, you get both equal marks.
Lordship,
Integrity, you have been given 1 mark less,
Lordship.
which has caused the difference. And in leadership, you should have got some more marks, and
Some
you should have got less marks.
Got
And overall seniority, you are 5 years
5 years seniority.
seniority.
Lordship. And there is also violation of Rule 13 of the Assam Civil Service Conduct Rules 1965, because when she obtained her B.Ed degree from Diomono B.Ed College, which is in Moholdoi district, which is Lordship 271 kilometers, 6 hours 40 minutes road journey, and that was a day shift college, Lordship, without obtaining
A regular course.
in a regular course, without obtaining permission. That is in violation, and the Director of Secondary Education Assam has taken a consistent stand. Also, I will produce two orders in this regard. Lord. May I please?
Now, what is the position?
Respondent number 6 is holding the post of principal, and I'm working as an assistant teacher.
Order is
This is a hearing report in respect of 2 other teachers in two different schools, and DS's order is dated 21/2020 in respect of Bodrinath Pandey, wherein it has been held that if you do not obtain permission from the competent authority.
let us see Bodrinath. Bodrinath.
Yes, Bodrinath. Paragraph 75 and 78 and 79.
Paragraph
75, 78, 79. Lordship, I would like to place one more order passed by this honorable court, Lordship. 2 orders, Lordship.
First, let us read Bodrinath.
Yes, Lordship. Paragraph 75, Lordship, from the last portion, Lordship. From the records produced by the learned additional solicitor general.
This is paragraph 74.
74, yes.
74.
Yes. From the records produced by the learned additional solicitor general, we find that the committee which interviewed comprised 2 of the persons against whom the respondent had filed contempt petition in the High Court. This, in our opinion, was neither proper nor fair. Those officers who are occupying very high position in the bank in all proprietors should have withdrawn from the committee constituted for this purpose. We may not be understood as imputing any bias to them, but in our opinion, the principle of fairness required that they should not have sat on the board.
Yes.
Then paragraph 78. In our view, Sri V. Kartikeyan must have rescued himself from the committee as he did not do so, and as he participated in the decision-making process and disqualified the appellant. The entire recommendation stated 38/1979 of the screening committee must be treated as vitiated and invalid. Then 79. In the light of the above finding, we do not think it necessary to refer to the various other allegations against Sri V. Kartikeyan as regards actual malafide, and we feel that it is sufficient to go by the principle of real likelihood to quash the report of the joint screening committee. And there are other paragraph also. Paragraph 85 also is here. We have
That is
already-
on bias.
Bias. Hmm?
You have other
79,
grounds.
yes.
You have other grounds also. Try to expand on the other grounds.
Yes, Lord. Now, with regard to lordship, that integrity and ACR mark has been given by the president of the SMDC lordship. In that respect, lordship, this honorable court has passed an order.
Integrity?
Integrity and ACR mark is which have been given by the inspector of school. Instead, lordship, the president of the school selection committee has given that mark, lordship. In that case, lordship, I am facing one order, lordship, passed by the
Given
honorable
by
court.
president? Given by president of SMDC,
I think SMDC, lordship. Dr. Sumitra Pujari,
not by the.
not by
TS.
the lordship inspector of schools. Benudhar Das, lordship, it is seen, paragraph 5. It is seen in the instant case that an officer who was not holding the office at the relevant time had reported the ACRs. In the event the ACR was not reported by the appropriate officer who was holding the office at the relevant time, the law provides for an alternative.
Paragraph
procedure.
you are reading,
Paragraph 5 of Benudhar Doctor.
order dated.
Order dated
28/3.
28/3/2018.
WPC
WPC
3050.
3050/2017.
Paragraph.
Paragraph 5. It is seen in the instant case that an officer who was not holding the office at the relevant time had reported the ACRs. In the event the ACR was not reported by the appropriate officer who was holding the office at the relevant time, the law provides for an alternative procedure as to what has been done. The aforesaid anomalies as indicated above are not disputed by the respondents hearing. In view of the above, it is deemed appropriate that the interest of justice would be met if the selection committee would undertake a de novo selection strictly in accordance with the guidelines provided in the order dated 23/3/2016. It is ordered accordingly. The result of the selection that selection committee may take upon such de novo exercise shall prevail over the earlier selection. So this was interfered with when the other person had forwarded the ACR. And now, let's say with regard to her B.Ed degree from Diomornoy, this honorable court, her classmate had obtained, her roll number was the 75 and 76.
What is the name of the college?
The Diomornoy B.Ed college,
Here?
same situation. Almost
Name
same
we have not got. Name we have not got.
situation. Diomornoy B.Ed college.
How to spell it?
DEOMORNY. Diomornoy.
Deo Mornoi.
No.
Dorong.
Dorong.
What are you relying with this to?
Lots of the entire judgment because this Bonali Sokia Kakoti and the respondent number 6, they took admission in the same year. Her roll number was both her roll number even also were 75 and 76. And she also obtained her B.Ed degree as an in-service teacher from Padmaram High Secondary School, York. And this honorable court has held. Lordship, kindly see the last portion, Lordship, paragraph 24. Lordship, may kindly go paragraph 23 also. From the Lordship, may I read paragraph 23?
Yes.
From the record, from the perusal of records, it is seen that Inspector of School Zorat, after making the inquiry with regard to the petitioner's claim, and her B.Ed degree submitted his report before the DSE Assam on 26/2022, and on the basis of the said report, the authorities in the Directorate of Secondary Education Assam found that the petitioner attended the normal classes in the school her way of obtaining B.Ed degree is irregular and that she could not establish as to how she attended the B.Ed classes in the college concerned regularly from Madhavpur, Jorhat to Diomorna, Dorong, Mongoldoy, which is 350 kilometers away. Since she did not take any leave for acquiring the B.Ed degree course that requires 80% regular attendance in B.Ed classes, which could not be found with regard to the petitioner, and the petitioner has failed to place before the authority, and she also failed to produce no objection certificate for the B.Ed course from the authority concerned, where the final examination of B.Ed 2015 was held in the month of August. Relying on the provisions of Rule 13 of the Assam Civil Service Conduct Rules 1965, that reads as no government servant while in government service shall join or attend any educational institution for the purpose of preparing himself or shall appear at an examination of a recognized board or university without obtaining previous permission from the appointing authority. The respondent authorities found that the B.Ed degree obtained by the petitioner is irregular and is in violation of the said 1965 rules noted above. It was also brought to the notice of the court that presently the inspector of schools, Jorhat, is in charge of the principal as well as DDO of Sri Padma Ram Sharma High Secondary School, Titabar, for payment of salaries, etc., of the teaching and non-teaching staff of the said school. Then also the matter was remanded back by observing all this. And the hearing, Lordship, the hearing report I have already given, Lordship. The director stance in this case I have already given, Lordship. With regard to Bonali Soika, that has been recorded.
Where is it?
Lordship, I have already given two hearing report in respect of one
Okay,
Bodrinath Pandey and
okay.
Bonali Soika. The DS's stand is very consistent, Lordship. They have said that her beard cannot be treated as a is irregular. Also, there is another aspect of the matter. The coordinate bench of the Honorable Court has held that as per Rule 13(2) of the Statute Lordship, the school selection committee cannot make merit assessment. It is already in the rule of Lordship, and as order has been passed by the Honorable Court. Lordship, may I place it? The school selection committee, on the basis of the Lordship documents, biodatas and Lordship the administrative ability certificate, they are only supposed to send 3 names to the state selection board. Lordship may kindly see Rule 13(2), and it is the finding of the this Honorable Court. Rule 13(2).
Which case?
Tolokonath Das.
Which
Also, I have highlighted Lordship relevant portions. If your Lordship, it is at page 377.
okay, we'll continue.
So I was referring to Rule 13(2) of the book, Lordship, page 377.
2003 rule.
2003 rules, Lordship.
Page
377.
of this book.
Lordship, of this book.
377. Yes.
Rule 13(2) states, Lordship, on receipt of the application from the eligible candidates, the school selection committee constituted under Rule 8(4), after scrutiny of the application, shall hold an interview and prepare a panel of names of 3 candidates on the basis of qualities such as leadership skills, administrative ability, integrity, and commanding personality. The panel of names so prepared by the school selection committee shall be forwarded to the concerned inspector of schools to the state selection board constituted under Rule 16 for approval. Now, Lordship, may kindly come to the judgment which I have read before your Lordship. That is WBC 2373 of 2019, Troilokanath Das. That judgment was delivered on 25/11/2020.
Yes.
Lordship, I am relying paragraph 4 of the said judgment.
Yes.
A reading of Rule 13 of Rule 2003 shows that before the end of each year, the member secretary of the school selection committee shall invite applications from intending eligible candidates through an advertisement, which in fact had been done as per Annexure 8 advertisement dated 17/12/2017. Rule 13(2) of the Rule of 2003 provides that on receipt of the application from the eligible candidates, the school selection committee considered under Rule 8(4), after scrutiny of the application, shall hold an interview and prepare a panel of names of 3 candidates on the basis of leadership skill, administrative ability, and rank and commanding personality. The expression used in Rule 13(2) of the Rules of 2003 is that the school selection committee shall prepare a panel of names of 3 candidates. The rule clearly indicates that there is no requirement of arriving at any inter se merit assessment by the school selection committee as regards the panel of 3 names that are to be prepared. Rule 13(3) of the Rules of 2003 provides that the panel of names prepared by the school selection committee shall be forwarded to the state selection board considered under Rule 16 for its approval. And Rule 13(4) provides that after receiving the panel of names prepared by the school selection committee, the state selection board shall prepare a select list equal to the number of vacant posts. Paragraph 5, Lordship, we have taken note of that requirement of the school selection committee is to prepare the panel list, meaning thereby that the list so prepared would contain only the names of 3 candidates, as may be recommended. In the aforesaid circumstances, the school selection committee of Sangha Higher Secondary School prepared a panel of names of 3 candidates comprising of the rich petitioner, respondent number 7 and respondent number 8, although it was not a requirement under the rules. The school selection committee for its own reason had also stated the marks given to the respective candidates, leading to a dispute by the respondent number 7, Sri Dharmananda Thakuria, that he was given less marks. As the rules itself did not require any inter se merit assessment to be made by the school selection committee, we are of the view that marks indicated by the school selection committee is irrelevant and has no effect in the eye of law, and nor any such marks given can be further acted upon by the state selection board. And paragraph 8, Lordship, paragraph 8 in the middle, Lordship, it has been stated that the matter shall now be processed further by the authorities by considering the list prepared by the school selection committee to be a list under Rule 13(2) of the Rules of 2003, meaning thereby that it is a list of panel of 3 candidates. So the school selection committee cannot make merit assessment. They will only send the 3 names before the state selection board in terms of their biodatas, the certificates given by them in respect of administrative ability and commanding personality. And the state selection board is to prepare the select.
While the list is being prepared by the school selection committee, it's after all committees, selection committee. They have a panel of 3 candidates.
3 candidates.
Now there may be many candidates.
Yes.
And out of those, the panel has to constitute only 3 members.
3 members.
So there has to be a process of including somebody and excluding somebody. That apart, 3 names are to be in a panel, okay, one after the other. All the 3 cannot be at part. 1, 2, 3. So how is it that? Can you say that they are without any powers to make a selection? They are not the appointing authority. They are recommending the selection to the state selection committee
by awarding marks.
So how do you?
As per rule, Lordship, they are only supposed to send a name.
Names of, suppose there are 7 eligible.
7, yes. So they have to scrutinize among them, Lordship.
That is it. Is it
Who are the
not,
senior most and who
is
has
it not a
better
selection
credentials,
process?
who has better credentials.
Is it not a selection process?
Yes, it is a selection process.
Then
But the rule says, and Lordship, the finding of the honorable board is also, Lordship, that
now we are only on the rules.
Lordship.
Can you say that the school selection committee is not vested with any powers to make a selection? Preliminary selection is done by school selection committee. A person who is not selected in the panel of candidates, he can also make a grievance that yes, I am a better suited candidate.
It is there.
Now, in a given case, school selection committee may act illegally and deprive eligible candidate from the panel,
No.
who otherwise thinks that he should have at least should have been considered for in the main selection by the state selection committee.
Lordship, what, from this, Lordship, it is, as per the rule, Lordship.
Let us see the rules again.
Rule 13(2).
13(2) on the receipt of
377.
application
Yes.
of from eligible candidates,
Yes.
school selection committee constituted on so and so, after scrutiny of the application, shall hold an interview
And
and prepare. What is the purpose of holding an interview?
enter. To select the three candidates.
That is it.
To select the three
If
candidates.
it was a mechanical exercise
Lordship.
that based on the documents we prepare three candidates,
Yeah.
the question of holding interview and the parameters have also been laid down. Qualities such as leadership, administrative, integrity and commanding personality, those are also listed. But how is this submission of yours coming in your case?
Because I have alleged malafide against the biasness and malafide against the school
That,
selection
that
committee.
you can still you can
That is why also I have.
that submission you can still support without even taking reports. While giving marks,
Lordship.
that's a different matter. They did not have any powers even to allot marks.
Right.
But even while allotting marks, your allegation of bias can still be considered or examined.
Right.
I think Pralok could not, thus you did not even, I think, mention this point.
And just lastly, Lordship, I have made an RTA application, Lordship,
Hmm.
with regard to her obtaining B.Ed degree, and it has been settled by the school authority that she did not obtain any permission and deputation. Okay.
By R6,
By us.
no permission from the school for pursuing B.Ed course.
And Lordship, recently, Lordship, my learned friend appearing for respondent number 6 has filed an affidavit, additional affidavit on 26/6/2023. In paragraph 6, he has alleged that I have refused to hand over some files and instead she disappeared for more than 20 days for a particular period, Lordship. With that respect, Lordship, I was on medical leave, Lordship, I have documents.
Yes. That's all.
That's all.
Respondent number 5, presence in the selection committee
Lordship.
has caused bias.
Lordship.
That is your first point.
Lordship.
Number 2, in the selection held,
Lordship.
you have also said that the school selection committee does not have the power to make any merit assessment. But even ignoring that, you said that the marks allotted are not in accordance with the, are not does not correspond to the materials on record. And thirdly, you say that the essential criterion of BEd of the S1 number 6 cannot be recognized because it was not obtained in by following the due process of law. Mainly these are the yes.
And Lordship, two orders I have given Lordship that the stand of the Director of Secondary Education, they have taken a consistent stand with regard to Assam Service Conduct Rule. So in this case, Lordship, there cannot be a different stand. That is my contention. In respect of Bodrinath Pandey and Bornali Sogia Kakoti, I have placed 2 hearing reports of the Director of Secondary Education. They have taken a stand. Like in case of permission not being taken, Lordship, our BEd cannot be considered. So in this case also it is same. So they cannot take a different view. Lordship.
Yes.
And in the integrity and STR, we have got very good, so marks should be equal. Lordship. And more importantly, the mark was given by the President of the Assembly. So it is to be, in that respect also I have placed one order. Benudhar.
Just a minute. Yes.
I have got the reconstructed record, my lord, though it's not sufficient. Otherwise, ACR is not here, my lord, in this record. Only the minutes of the selection committee and the comparative assessment chart, my lord. So his first argument that, my lord, the respondent number 5 is the member secretary of the selection committee. She was aware of that, my lord, because being the principal of the school, my lord, she will be the member secretary of the selection committee. But while appearing in the interview, my lord, she did not object to it, my lord. After being unsuccessful, my lord, now she is objecting to it, my lord.
Principal is act officio, ma'am.
Yes, my lord, as per rule, my lord. So she was aware of that, my lord. It is not her case that she was not aware of it, my lord.
Yes.
As regards the BEd qualification obtained by the respondent number 6, my lord, in the months of document, my lord, I have given office memorandum, my lord, page 6 of this bunch of document, my lord. This is a report from the inspector of school. In this report, my lord, last paragraph, from that sir.
Yes.
That sir, Srimati Madhuri Borthakur, the petitioner had joined in Malwali High Secondary as an assistant teacher and
What
have
is
been
your name? Madhuri Bhatt.
Madhuri Borthakur. As an assistant teacher and have been rendering her services till date. In pursuance of the advertisement dated 19/6/2016, she had applied for regular principal selection at the school, is held at school level under school selection committee. The office of the undersigned is by no way involved in this selection process except for in the panel list prepared by the school committee, school selection committee to the state selection committee. Next page, my lord. In regards of the authenticity of the B.Ed of the respondent, the office memorandum relating to deputation of teachers of higher secondary schools to undergo B.Ed training issued 28 July 2014, dated so and so, can be taken into consideration. As per para 6 of the aforesaid office memorandum, any PG teacher, graduate teacher in provincialized higher secondary and high school stroke high madrasa with relaxation of professional qualification of B.Ed degree as government notification number so and so, dated so and so, may pursue B.Ed degree from the B.Ed colleges in the state which have affiliation by the Guwahati University, Dibrugarh University and Assam University in the evening shift classes where normal classes of the school are not hampered. No prior permission shall be required. The teachers who desires to obtain B.Ed degree from such college may get admission with intimation to respective head of the institution and the inspector of schools. The competent authority shall grant leave to enable the teachers to appear in examination, practical classes, etc. So in the-
Evening shift.
yes, my lord.
Permission is not required for evening shift.
Yes, my lord.
Was this an evening shift?
Well, that is not reasonable, but while appearing in the examination, my lord, she took leave, my lord. The respondent was 6 took leave, my lord. That document is with me, my lord.
Examination leave and leave for pursuing a full-time course. That too during the day.
Here, my lord, whether she had appeared in the day shift or evening shift, that is not reasonable from this document, my lord.
That is the categorical submission.
But my lord, there is a page 13, my lord, in this bunch of document.
30.
13, my lord. 13, last page, my lord.
Yes.
The respondent number 6, due to non-attendance, my lord, she was non-collegiated, my lord. And for that, my lord, she had paid a amount of rupees 4,500 to appear in the examination. And she took leave, and in page 11, my lord, this is the examination schedule, which starts from, my lord, 29/8/2015 to 29/9/2015. Within this period, my lord, she took leave. That leave order is at page 10, my lord.
Page 11 is what?
Page 11 in the examination schedule, my lord. From 29/8/2015 to 29/9/2015. And page 10 is the order, my lord, whereby she was granted the leave, my lord, for that particular period. And my lord will find the office memorandum at page 8.
Are you disputing that it's the evening shift?
No, my lord, I am not disputing, my lord.
No. The petitioner has made out a categorical, has made a categorical submission that the B.Ed degree was obtained by the respondent, prior respondent, on a regular basis from a day course.
Yes.
He has said that for evening course, permission to pursue is not
It's not
required.
required, my lord.
Only for appearing in the examination, leave application needs to be
Yes, my lord.
given. Here, he has said that leave application indeed is there for examination.
Yes, my lord.
But you have not stated whether this particular college impart the classes for B.Ed in evening shift.
Honestly speaking, my lord, that instruction I don't have. But from the instruction received from the inspector of school, my lord, it is assumed that, my lord, she undertook the courses in the evening shift, my lord. Because since the inspector of school relying on the OM dated 28th of July, my lord, so it can be assumed that, my lord, she has done her
We can assume when he is vague or he has not stated anything. His categorical statement is that it is not done and the distance is 270 kilometers.
Distance is well. Distance. I'm not disputing the distance because from Jorhat to Dorong, it's around 200 kilometers, my lord. So, as regards, but the respondent was sick. She was non-collegiate also, my lord, since they did not appear in the regular classes. So that receipt also I have.
See, being non-collegiate is one factor, but if he has not taken permission to pursue a regular course, that will have different connotation.
Yes, my lord.
She may be absent in a regular course,
Yes, my lord.
she may be absent in an evening course.
Yes.
Isn't
Yes,
it?
that.
Being absent in an evening course may perhaps be in the advantage of Mr. Pothak. But if she is not present in the day course, that will not make any difference.
Yes.
Because to pursue the day course, you need to have permission. Whether you are present in the class or not, that's a different,
Yes.
that is a different matter.
Since, my lord, we are relying on this office memorandum, my lord. That is why I am submitting, my lord, that
But what about these two orders passed in by the DSP, one in Badrinath, one is Bornali, Saikya, Kakoti?
that in fact I have not gone through it, my lord.
Have a look.
Body not conduct.
লাগিব দেখোন। You can go through those, anything else?
Regarding this, my lord, Bornali Kakuti, my lord, here, my lord, she could not establish that she was attending the classes, my lord. Whether it was day shift or evening shift, that has not been mentioned in this order, my lord. And here, my lord, we are saying that, my lord, we are relying on the OM dated 2014, where if the person appeared in the evening shift, my lord, then it is permission is not required. So here from this order, my lord, order by the director, my lord.
Mr. Das, in which paragraph have you stated that it is a full-time course?
Full-time course, sir. Yes. Paragraph 19, though the recommended candidate serial number 1, Samolina Bora, respondent number 6, though is MA, but as an in-service subject teacher, she has obtained BA degree from Deomorna College, Mongoldo in 2016, which is not less than 150 kilometers away from a school, which is humanly not possible, and that too without deputation, study leave, and sense of obtaining prior permission from any of the competent authorities. So her off-campus BA degree cannot be taken into consideration as a valid BA degree.
Mr. Pothak, was it what day course or evening course?
Lordship, that instruction I don't have. Since your lordship, he has not pleaded that nowhere that it is a day course. Unless there is a specific pleading that it is a course in the day, your lordship, I need not take instruction. I don't have that instruction. But whatever I have, your lordship, I have an. And Bornali
As far as the environment is 19 is concerned, that can perhaps be taken care of say by this notification. because permission or deputation is not a sine qua non,
Sure.
provided it's an evening court. But he has not said it here.
And Lordship Bonali Sokia Kakoti and Madhuri Bhattakur, they were classmates. Bonali Sokia Kakoti's roll number was 75 for the same session, 2014-15. And Madhuri Bhattakur's Lordship same roll number was
Mr. Das, we cannot presume because one college may offer both evening and day.
Lordship.
Only because one of our colleagues had pursued her B.Ed as a day student, regular student. Other may not.
Lordship, in Diamona B.Ed college, there is no evening shift. It is only from
Where
10
have you
to-
stated?
Lordship, let me see. Lord.
You show us that. You may be correct, but it has to be on record. Can't you get the instructions whether it's a evening shift or
Yes, my lord.
day shift college?
That can I, that instruction I can obtain, my lord.
Yes.
During the relevant period of time.
Lordship, otherwise, your Lordship, my submission would be.
We are hearing. Okay. Is anything else?
No, my lord.
What is your age, Mr. Water?
Is your
Age.
Is-
For R5
R5.
or 6, R6.
R6. My age, your Lordship, will be 51, 52, your Lordship.
And Das?
Lordship.
You
My
read?
age would be Lordship around 58, 59 now. Lordship, 50. In the affidavit, it has been given as
60 years is the date of the birth.
Yeah, he will be retiring next year.
next year. I will be retiring next year. 52. In 2017, I was 52.
Minutes. I'm only minute. Sorry, I can-
65.
58 or 59. Lord.
My 67 date of birth or date of. He's 65, 2 years.
My date of birth is 65.
First of all,
She is
your
67.
Lordship,
Yes.
certain documents were placed before this honorable court, your Lordship, but those were not brought on record, your Lordship. It is and over to your Lordship. And I did not get any opportunity to either to go through or controvert. That's the part, your Lord, just for submission. Basically, his case is, your Lordship, is the first ground, your Lordship, is that of the presence of the respondent number 5 against whom he has preferred. It. And if your Lordship takes up the rule 30, your Lordship, of 2000, page 370, rule 18, your Lordship.
That's right.
Rule 373, your Lordship. Starts from 372.
Three 70.
Your Lordship.
Yes, we have.
That book,
Rules of 2003.
2003. Rule 8, sub rule 4.
Rule, sub-rule 4, the school selection committee for selection of principal, postgraduate teacher, graduate teacher, and non-teaching staff. Your Lordship. Principal, your Lordship will not.
Yes.
Shall be as follows. Chairman, the president of the managing committee, the vice principal, postgraduate teacher in case of a higher secondary school, or assistant headmaster, senior most graduate teacher in case of a high school. One parent to be nominated by the managing committee, member secretary, your Lordship, the principal, headmaster. Respondent number 5 was the principal, your Lordship, at a relevant point of time. In view of the rule, your Lordship, he automatically becomes your Lordship.
Access.
And your Lordship will kindly note, before participating in the interview, if she feel aggrieved in view of her presence, she should have.
Suppose an in-charge principal wants to participate in a selection,
Right.
who also has the B.Ed degree.
Right.
In that case, what would happen?
Your Lordship, in that case, your Lordship, what happened, your Lordship, a postgraduate teacher is your Lordship allowed. to-
That means, in spite of the rules providing that the member secretary has to be the principal or headmaster, in a given case, it can be somebody else also.
Yes, sir. A given case.
It is not that he or she has to be the headmaster.
Lordship.
In a given case, it might change.
Now, your Lordship, that is true, your Lordship. What has fallen from your Lordship not. But at the same time, your Lordship, how do the authorities, your Lordship, who constitutes the committee, your Lordship, will know that she may feel aggrieved in view of her presence? Is it not her duty to point it out immediately? That I have filed 2 cases against her. Her presence may create a biasness
When
against
the respondent number 5 herself was not a candidate. So
Lordship.
if she was a candidate, then obviously the she ought to have recused. Now here, unless the objection has been raised,
And pointed out before interview, your Lordship. Now, who will know, your Lordship? Neither me, your Lordship, nor the authorities, your Lordship. No one can go and peep into her mind, your Lordship, what is there. And she has only after participation of the interview, your Lordship, she submitted a representation, your Lordship, which she has annexed, your Lordship, that is at page 57, that is 26 December 2016.
okay,
57.
yes,
And your Lordship, this next
one more.
Lordship.
Member secretary is go ahead.
Lordship. And date of selection, your Lordship, previous page 16/11/2016. So after
11,
2016.
and this is the first letter.
First letter. Apparently, your Lordship, since he has not annexed any other letter, your Lordship. Now, going by the principle laid down in modern law and other cases, your Lordship, please divert from raising this issue, your Lordship. For that, I am relying on modern law and others versus state of J&K, your Lordship. 1995 3 SCC 486, para 9 and 10. Copy I will hand over.
That was based on Om Prakash.
Lord, Om Prakash is also there. I will hand over.
What is the citation? 1990?
Your Lordship, 1995 3 SCC 486, para 9 and 10. Now, so far as the giving marks by the your Lordship, the president is concerned, your Lordship. He has not, it is not his pleaded case, your lord. We don't know about that. It will only can be revealed by the record, your lordship. Record of your lordship, ACR, your lordship. That is neither not before your lordship as of now, your lord. Now that was not pleaded by him in his writ petition, your lord. Unless he pleads it, your lordship, he cannot make a statement like this, your lordship, that this was mark was awarded by the
Mark in the selection.
in the category of the ACR, your lordship. That president and chairman of the managing committee, someone Sombitra Pujari, has awarded the mark. That is his statement before this honorable court, your lordship.
That is an oral submission.
That's an oral submission. There is no pleading so far as that submission is concerned. I have not found. If we have made, your lordship, he will point out later on.
Is there no pleading?
Lordship, during the deliberation of the, after publishing the record before the honorable court, during the deliberation, it has come out, lordship, that committee repository has ordered marks. That is not recorded by your lordship, nor in the pleading. How can your lordship can take? It was 19/6/2016, 19/6/2019, lordship, when the lordship, the court was supposed to take in a prima facie view in favor of the petitioner, and suppose the order was supposed to be passed on the next day, lordship. And that was not a prima facie view in favor of the petitioner. Although it was not recorded, but after perusal of the record, it has been seen that lordship, the assembly president Soumitra Pujari had awarded mark. We cannot presume, your lordship, unless there is some material report is on our court, your lordship.
Read court, Mr. Das. No scope of evidence. Pleadings supported by an affidavit. This matter is pending since long. You have not filed an additional affidavit. And without giving a chance of rebuttal, something which has not been pleaded, can we take cognizance? Because the record was very much there. Now only they have said that the record is not available. The record was along with the. No, we have to go by what is available now. What are the whatever material? Yes, next. Then your lordship, coming to the point, your lordship, of rule 13(2), your lordship, that is also a, your lordship, there is no pleadings as far as that is concerned, your lordship. But your lordship, since he has relied on the rule, your lordship will kindly note, your lordship, rule 13(2), your lordship, as your lordship has fallen from your lordship mouth, your lordship, on receipt of applications from the eligible 13(2), your lordship, eligible candidates, the school selection committee constituted under rule 8(4), after scrutiny of the application, shall hold an interview, your lordship. And what is the purpose of holding an interview unless, your lordship, they award marks, your lordship? And ultimately, your lordship, they have, your lordship, hold the interview and prepare the panel and send it to the state selection board. Ultimate final approval authority being the state selection board, your lordship, they have approved it, your lordship, finding everything is as per rule, your lordship. So, your lordship, that since, your lordship, I have not gone through that judgment, your lordship, which has been relied on my friend, your lordship. But apparently, your lordship, that some exercise, some application of mine on the part of the school selection committee will always have to be there, your lordship. Tell us about your
I will come to
your reply to the PA allegation.
Lordship, I will come to that, your lordship. And then there are two other grounds, your lordship, he has telling his mind. One is, your lordship, in para 16, your lordship, the award of marks in the head of leadership skills, your lordship.
Yes.
He has, your lordship, calculated the marks, your lordship. Apparently, in an objective manner, he tried to, your lordship, portray it. But whether the selection committee followed this procedure or not, that is the issue, your lordship. Because why this is, your lordship? Your lordship will find after 2018, your lordship, the office memorandum issued by the authorities, your lordship, the authorities in the education department, your lordship, your lordship will find in the leadership skills, marks are awarded, your lordship, up to 59% mark of HSLC or AHM examination. then your lordship, if it's up to 59% of pass, 59 pass percentage, your lordship, then your lordship 1 mark, then 60 to 79 2 marks, 80 to 89 3 marks, 90 to above 4 marks, your lordship. This is the procedure, your lordship, adopted by the your lordship as on date, your lordship. But in 2003, your lordship, that was not in the office memorandum, that was not mentioned. But I have made a submission, your lordship, by filing an additional affidavit that there was a guideline issued by the manual issued by the directorate, your lordship, which says, your lordship, how the marks will be awarded, your lordship. And against the HSSLC in respect of the subject teacher and in respect of a graduate teacher, the result of the HSL will be considered. And that way, your lordship, marks are awarded. And insofar as HSSLC result is concerned in my school for the relevant period, your lordship, it is more than 90%, your lordship. That is why, your lordship, I was awarded 5 marks and she was also awarded 5 marks, your lordship, since she also comes within that parameter, your lordship. That is the issue, your lordship. And he has not disputed that, your lordship, against my affidavit, your lordship. Thirdly, your lordship, so far as, your lordship, this award of marks in the this particular ACR is concerned, integrity, your lordship will kindly come to the writ petition. Page 53. It is not that, your lordship, ACR has 5 marks, your lordship. ACR has, your lordship, for outstanding 3 marks, for very good 2 marks, and for very good 1 mark. And there are additional 2 marks in the section of integrity, your lordship. Now, what are the considerations made by the selection committee? That is not before us, your lordship. That will be revealed by the record, your lordship. Because 3 marks maximum got from the ACR, your lordship, then also 2 marks remains, your lordship. And that 2 marks, your lordship, how they have considered it, your lordship, that will be have to be seen by from the record. It is not that having, your lordship, the very good for both, they will get 2 or 3, not like that, your lordship. If I am getting 2 in very good, your lordship, then I am getting 2 in the integrity. And for some reason or other, your lordship, she is getting 1 mark in integrity.
You mean to say that since the total marks
Are 5.
allotted are 15?
Lordship. 5, your lordship.
No, 15 total.
Total, your
Leadership, administrative, and integrity.
lordship.
So integrity means which will into these 5 marks for integrity would include
3 marks
for ACR also.
ACR only, and
3 for maximum I will get for ACR is how much? 3 marks.
3 marks, your lordship.
And integrity will be 2 marks.
2 marks. So, your lordship, that will have to be found from the record, your lordship, since we are not privy to that, your lordship, we cannot comment on it. But it is not that having the same grading in the ACR, both will get the same mark in the head of integrity. Now coming to the last, final, your lordship, most crucial point, your lordship.
Maximum in ACR you can get 3.
3, your lordship.
Is 3. Therefore, integrity maximum is 2 marks.
2, your lordship. So it may happen that, your lordship, I am getting 2 in ACR and 2 in integrity. She is getting 2 in ACR and 1 in integrity, your lordship. Therefore, your lordship, it will not be correct to say that having the same grade, your lordship, in this same standard in the ACR, your lordship, we will get the same mark in the head of integrity.
Correct.
Lordship.
Okay, next.
Then, your lordship, coming to the last point, your lordship, that the BA degree, your lordship. As of now, your lordship has already seen that document, your lordship, which has relied on by my friend, your lordship. It says that so far as evening classes are concerned, your lordship, that they are exempted, your lordship. No permission is required, and we don't know, your lordship, whether it is evening or, your lordship, day shift, your lordship. That will have to be, your lordship, as has been done in the other cases, your lordship. that will have to be done by the exercise will have to be done by the director, your lordship, since there is a question about that. Otherwise, your lordship, as on date, my degree not having been challenged in this writ petition, your lordship, it is still a valid degree, your lordship, until and unless any of the authority, either by this honorable court in a specific challenge to my degree or by the director, your lordship, take this decision that my degree is not a valid degree in view of these are the provisions, your lordship, my degree will remain valid. But since she has raised the question about that, your lordship, that probably, your lordship, since that has not been put to challenge before this honorable court, your lordship will have to probably, your lordship, remand the matter back to the director to take a call on that, your lordship. Otherwise, your lordship, it is still holding the field, your lordship, my degree, your lordship. And there will have to be an order by either by this honorable, and that is why, your lordship, he has put my degree to challenge in a different writ petition, your lordship. Probably in that petition, your lordship, notice has been issued, your lordship. He has, your lordship, he has ultimately, your lordship, find that until and unless the degree is challenged, your lordship, it will hold the field, your lordship. Rightly, wrongly, your lordship, an authority has issued a degree which is otherwise not ineligible to issue a degree, your lordship. I am holding it, your lordship. If there is any irregularity in that, your lordship, that
Irregularity is only on the procedural.
procedural, your lordship,
Substantive degree as such has not been put to challenge.
not been put to challenge, sir. One judgment, your lordship, I am relying on, your lordship. I am trying to draw analogy of this, your lordship. Your lordship will para 8, your lordship. Para 8, your lordship. In Halsbury's laws in England, 4th edition,
1996,
Lord,
166,
435.
para
8, your lordship.
Yes.
If an act or decision or an order or other instrument is invalid, it should in principle be null and void for all purposes. And it has been said that there are no degrees of nullity. Even though such an act is wrong and lacking in jurisdiction, however, it subsists and remains fully effective unless and until it is set aside by a court of competent jurisdiction, until its validity is challenged, its legality is preserved. Then, your lordship, next paragraph, next line, your lordship. Every unlawful administrative act, however invalid, is merely voidable, but this is not more than a truism that in most situations the only way to resist unlawful action is to recourse to the law. In a well-known cases of so and so, an order, even if not made in good faith, is still an act capable of legal consequences. It bears no brand of invalidity upon its forehead unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset. It will remain as effective for its ostensible purposes as most impeccable of order. Now, your lordship, this has been your lordship, the view accepted by the apex court, your lordship. Now, having understood this, your lordship, he has preferred a writ petition. Now, ultimately, if that writ petition, the issue is decided, your lordship, against me, then I am out, your lordship.
what is the petition?
WPC number.
WBC 1, lordship, on the first day, lordship, I have given the order, lordship. It may be in the file also. lordship.
Number.
Lordship, WBC 1733 of 2020.
Credit free.
Lordship. WBC 1733.
What is the stage?
Lordship, in that case, Lordship,
Notice was issued.
You have entered appeal.
We have
I have
not
the-
yet,
I have the
Your
order,
Lordship.
Lordship.
We will, Your Lordship.
Lordship, we have taken justice service, but she refused to accept. Then we have taken rest.
That instruction I don't.
It is at the stage of service.
Service.
Service may be complete because we have also filed a justice affidavit saying that she has refused to accept. Then we have taken.
That is not an
We
issue
have taken
here.
register
But orders have not been passed till now.
No, no.
And finally, Your Lordship, one more predicament for me, Your Lordship. If Your Lordship decides to interfere at this stage, Your Lordship, already Your Lordship from 16, Your Lordship, around 7 years has gone by. The post I am holding, Your Lordship, has already been filled up by someone else. The post of assistant
Your
teacher,
substantive post.
substantive post, has already been filled up, Your Lordship. Now, at
What
this,
was the post you were holding before?
I am an assistant postgraduate teacher, Your Lordship. Subject economics, Your Lordship.
Hmm?
Subject teacher economics. This is my humble submission. In view of this, Your Lordship, probably Your Lordship, in the grounds he has basically relied on, Your Lordship, in view of what has been emerged from the record, Your Lordship, and the records published, submitted by the
Last submission of yours, suppose you have given case, if not in this case, the other case, it transpires as your year degree is held invalid. Then
Lordship, then Your Lordship situation.
consequences, we may not be very much concerned with.
Lordship may not, Your Lordship, but
We would be only our lookout should be that whether the process has been done by following the due process of law.
Lord.
This election.
And finally, Your Lordship will see, Your Lordship, that the marking pattern, Your Lordship, is such, Your Lordship, it is the subjectivity or application of subjective mind is very limited, Your Lordship. The way marks are to be given, Your Lordship. Way marks are awarded, Your Lordship. When that is there, Your Lordship, the scope of malafide also become less, Your Lordship. And in my humble submission.
Who are the parties here?
Lordship, the respondent number 5, despite service of notice, has not appeared.
By name.
By name.
By name.
By name.
He has retired, Your Lord.
They are retired.
Retired Golden.
Golden night. He has retired.
That's
Attorney, 5 is retired.
That instruction I don't have, my lord. But I'm a friend.
Her date of birth
On his,
is
on
her
his-
date of birth is 62.
He's
retired person, no?
62 is now
Retired.
61. my
He is
lord.
not retired. But when the repetition was filed in 2017,
But even otherwise, even if he has not appeared, Your Lordship, the very ground, Your Lordship, on which his case rests, Your Lordship, is in my humble submission, is Your Lordship, is not no left to stand, Your Lordship. Therefore, Your Lordship, in my humble submission, Your Lordship, his petition is liable to be dismissed, Your Lordship, in view of what has emerged from the record as well as the facts narrated in the dispute. This much.
Anything?
Lordship, with regard to the OM relied upon by the Lordship Standing Council, that is only pertaining to evening shift, and this college is a day shift college. And Lordship, the leave, with regard to leave, Lordship, I have already placed by the school authority has already stated that no permission and leave has been taken. And B.Ed curriculum requires 80% attendance plus practice teaching. So she could not have.
These are, Your Lordship, not in the pleadings, Your Lordship.
And Lordship,
Your Lordship, I will object to such.
No. Take care. First, this submission of yours needs to be essentially be backed by a pleading that the course which she had pursued is a regular course.
Because
Now they are relying upon an OM
Lordship.
which and OM and not an OM, a
This-
communication,
Lordship.
which has been issued in the context of this case.
Lordship, that OM Lordship is not
That is it. If the OM is not applicable,
Lordship.
why has it been brought in?
Because Lordship, Deomona College is a day college. That is why Lordship we did not think Lordship that we should write that it is a day shift.
No, no.
There is no evening shift. That is why Lordship we have not
no, no,
specific. There is no specific requirement.
Mr. Das, you must be
Lordship.
correct.
Lordship.
But this writ petition is of the year 2017.
17.
When this has transpired, that this could be one of the defense
Right.
that the college, that the course which respondent 6 has undertaken a BEd,
Right.
he had undertook in the evening shift. And this was one of the, it wasn't the offering, it has come.
Right.
You should have filed an affidavit.
No, Lordship, this instruction that has not been filed in the affidavit. This has been placed just now. Today only they have placed this Lordship instruction by the Lordship perhaps by the inspector of school. And Lordship, the permission authority is by the appointing authority, that is the director. Whether they have taken permission from the director.
The question of permission, again, we go back to the same issue. Question of permission would come only when the course is a regular day course. In
Yes.
the instructions,
Yes.
they have said that the permission is not required for evening course. It can very well be presumed that this course is an evening course unless you put something on record.
Lordship.
As on today, it's very difficult because it has after all come in a communication relating to this case. If a OM which specifically states that permission is required only for a regular course and this permission is not required for a night shift, and they try to justify or support the case of the respondent, there may still may be some irregularity in justifying, but it has to be brought on record.
And also with regard to the submission made by my learned friend, that BA degree was not put to silence. I have not put to silence, but in paragraph, in my prayer, Lordship, in prayer D, Lordship, it has been stated, a writ in the nature of mandamus shall not be issued, directing the respondent authorities not to treat the off-campus BA degree obtained by the respondent number 6 as an in-service teacher as a valid degree for the purpose of appointment of the principal. Only with regard to that, Lordship. I have not paid for nullifying her degree. Only for the purpose of appointing as a principal, her degree cannot be considered. That prayer is very much here in my writ petition, Lordship. And Lordship, with regard to Lordship, he has relied upon Madan Lal, Lordship. Madan Lal has been also been clarified, Lordship, if there is some glaring illegalities. That is Lordship Rajkumar, 1997, 9 SCC 527, Rajkumar and others versus Shaktiraj and others. I am relying upon paragraph 16, Lordship. 1997, 9 SCC 527. Rajkumar and others versus Shaktiraj.
There are other cases also.
Other cases also, Lordship.
The stringent application of
Lordship.
Madan Lal has been
Cannot be-
diluted to
cannot
depend on the fact.
Lordship.
At times he may not be aware that
Lordship.
there was some illegal.
Recent judgment is also different. Here, your lordship, there are large scale irregularities has taken place in Shaktiraj in a selection process.
But here,
And
Mr.
since
Das,
Lordship.
in your case, if you think you are the person who would feel who will have the perception of bias because of the presence of R5.
Lordship.
It is not a case that you have realized later on that this illegality has crept in, or there is anomalies, or some mass copying, or some external other things. Here,
After the
this goes into the root that there is a person in the selection committee
Right.
whom you think will not be fair to you because there were previous litigation. You took more than a month to even raise your first objection.
Lordship, after the school selection committee interview, Lordship, I have filed one complaint, thereafter another representation.
Where are those?
After the school selection committee.
Yes, where?
Lordship, that
First complaint is 26.
yes, first complaint is 50.
Yes, after more than a
50,
month.
More than a month, Lordship. But
Is
but the appointment was given in 2017.
doesn't matter.
After
Will not.
and the state selection.
That will even make your case worse. That you took a chance till the appointment was made.
And
If the appointment was made in your favor, you did not have any problem.
But-
Only because the appointment went against you, you thought that I should raise this
but
point.
Rule 13 says that the state selection board should verify the records of the school selection committee. I have already made my complaint and representation. So it was the duty of the state selection committee to verify. They did not verify. They simply endorsed the
At least you
recommendation of
should
the
have
school
immediately
selection committee.
seen a particular individual in the selection board. Either you say that I am not going to participate, or if I participate under protest, and immediately you notify the authorities that I apprehend that this outcome will not be a fair one. I apprehend bias.
And in the second writ petition lawsuit, this honorable court has I have placed the order lawsuit. This honorable court has in the while issuing notice has taken a prima facie view of it. That observation is also there.
Which one?
The second writ petition lawsuit, I have placed while issuing notice lawsuit. Because I waited for almost from 2019 lawsuit, the order was supposed to be passed. Only recently lawsuit I have filed this writ. Now that
One seven three three.
173.
Without thought of dictating now with all these documents, it's difficult to reserve it. Third, three, let's get our planet count for the petition. Whereas the Department of Secondary Education is represented by training of N.J. Khatuni. The response number 6 is represented by Sri S. Botakur, Planet Count. The response number 5 has chosen not to appear in spite of service, and this court has been apprised that the state response number 5 has retired from service on attaining the age of subordinate. Hearing is concluded. Three, Attorney at the Learner Standing Council has placed before this court certain documents pertaining to the case. Here is concluded.
Deeply
All right.
obliged. Deeply.
এখন
May please.
Yes.
Test appeal, my lord. We have challenged the judgment and order, my lord. Case 31, my lord.
Testamentary appeal.
Yes, my lord. Appellant my lord, is the son of original owner of the land, my lord. Original owner was, my lord, Binoy Bhushan Chanda. After his death, the land was mutated in the name of his wife, my lord. Although they are having, my lord, sons and daughters, my lord. But in the mutation order, my lord, it is included that Gitarani is the mother of the petitioner, my lord. Gitarani Chanda. Her name, the mutation order was first, my lord. Her name was included in the mutation, my lord. And she, my lord, it is, my lord, it is that, my lord, she executed a will, my lord, in favor of the respondent number 1. Respondent number 1 is the, my lord, daughter's son, my lord. Her mother name is Kalpana Rai Chaudhary.
Did you contest the probate case?
We contest, my lord, but my lord, we also, my lord, prepared the objection, but that objection did not file in the, my lord, court, my lord.
Why?
That we came to know after get the judgment, my lord. We prepared the objection. We have annexed also objection, my lord, but did not file in the court, my lord. The record may be called for, my lord.
Very good. Indian.
I have a copy, my lord.
This is in the form of first appeal.
My lord. No, from the original suit, my lord.
For H.R. Ahmed, Learned Counsel for the appellant, who has preferred this appeal under Section 299 of the Indian Succession Act 1925. Full stop. The appellant has put to challenge a judgment and order dated 27/3/2023 passed by the Learned District Judge Kokrajhar in Miss P suit number 3 of 2019, which was instituted by the respondent number
1.
Full stop. Admin. Call for the record. Let theft for service of notice upon the respondent be taken by usual mode. Theft by theft within 3 days from today. Full stop. List after 6 weeks, along with report on LCR as well as service.
Till then, my lord, status order may be passed.
Serious proof. Regarding what?
He will now.
Where is your IA?
I-
File an IA decision appeal. You file IA will consider.
Bless me.
Baru-
Your Lordship.
Barua sisters,
Lordship.
where is the other counsel? Doesn't matter. Yes,
Lordship, in this case, Lordship, the petitioner has assailed the order dated 10/10/2022 and order dated 7/11/2022 in MSC case number 30 of 2022.
it arises from MSP case.
Lordship.
What has happened?
Lordship, the application was rejected on default, Lordship, because of non-appearance of the counsel of the claimant, Lordship. Your Lordship, case of the petitioner is that the learned tribunal has failed to exercise jurisdiction, Lordship, conferred upon it, Lordship, by section 168 of the Motor Vehicles Act, Lordship, because the provisions of section 168 are mandatory, Lordship.
168.
168. Lordship.
Yes.
Lordship, if I may read subsection 1 of section 168. On receipt of an application for compensation made under section 166, the claims tribunal shall, after giving notice of the application to the insurer and after giving the parties, including the insurer, an opportunity of being heard, hold an inquiry into the claim, or, as the case may be, each of the claims, and subject to the provisions of section 163, may make an award determining the amount of compensation which appears to it, and to be just, and specifying the person or person to whom compensation shall be paid, and in making the award, the claims tribunal shall specify the amount which shall be paid by the insurer or owner or driver of the vehicle involved in the accident, or by all or any of them, as the case may be. Lordship, from a reading of this section, Lordship, the provision of this section is mandatory, Lordship. However, Lordship, because the claimant could not appear, Lordship, the case was dismissed on default.
Notice has been issued or not?
Lordship,
This case,
Lordship, notice was issued, Lordship.
they have appeared.
Steps was complete, Lordship. However, they have not appeared, Lordship.
Usual process, received by respondent, then received by neighbor, received by mother, 1, 2, and 3. Registered post. Ethics are received but without signature. Who are the who's the insurance company?
Lordship,
IFCO
Orient,
Tokyo.
Lordship, Lordship, IFCO Tokyo, yeah, general insurance, Lordship.
Who generally appears? Mr. Chaudhary? IFCO Tokyo, any idea?
Maybe Mr. Goswami.
R. Goswami.
R. Goswami, probably. Madam will know.
IFCO Tokyo, yes, madam is there. Who appears normally?
This is a very, limited case with this company, so I have no idea.
They have counsel from Japan,
Maybe they imported.
imported counsel.
Yes. They can send a no address or address.
No, they have been served actually. And I think somebody appears once in a while.
RG Bora Road is Zulu.
There are decisions to so.
Lordship, the law has been is settled, Lordship.
Let us see. Powers of dismiss for default. Dismissal. Does it have the power or what is the procedure?
Judgment of this.
What is the procedure? To file it.
Lordship, paragraph 8, Lordship. Lordship, here it is clearly stated that law is well settled by a canon of decisions that an application for claim for compensation cannot be dismissed on account of default. If the claimant does not appear or fails to take steps or does not come forward to prove his claim, the learned tribunal has the power to adjudicate the claim on the available materials and record on merits, and accordingly he may pass award to the effect that the claimant is not entitled to get any compensation as the claimant could not prove his case. Even in case of repeated adjournment and non-operation by the claimant, the claim petition could be adjudicated on merits even in absence of a claimant, by granting award of compensation that may be justifiable on the available documents, Lordship.
Where is the Supreme Court?
Lordship, Supreme Court judgment, Lordship, in this judgment, it has been relied, Lordship.
2009
SEC 394, Lordship. Lordship, I have the judgment.
But I think we'll have, you do one thing, madam. Can you serve justice on the response number 1?
Lordship will do it, Lordship.
Other respondents may not be too much voted. You are the claimants, aren't you?
Lordship will.
You serve justice upon the response number 1. Plus the against the service report to the state. Second petition. Flag X. What is the address, madam? Of response number 1.
Lordship, this address was given in the application, Lordship, and the insurance company appeared, Lordship.
No. See the that is your application. See, represented by the branch manager of Louis Automobile.
sir.
How?
Well, Lordship, the insurance company accepted the notice, Lordship, from the MSC case, Lordship.
No, here there is a signature, no doubt. But the seal is of Louis Automobile. How is the Louis Automobile connected to a photo?
We will make an endeavor to find out, Lordship, if there is any other.
How can it be a branch manager by another unit, some Louis Automobile? Nothing to do with an insurance company. Niharika Saharia, you just say the service report. And we could have just accepted, but there is a still.
Niharika Sahari of Louis Automobiles.
See the still.
Lordship, Louis
Round
Automobiles. Louis Automobiles, Lordship. Lordship, I'll find out, Lordship. If
Just find it out.
Lordship,
Okay. We don't have any difficulty on your merits of this case, but just want to get the procedure correct.
Lordship.
Office note dated 8/5/2023. Reflect that so far as usual process, so far as service by usual process is concerned, comma, the response number 1 has been received by the respondent, semicolon. Response number 2 received by the neighbor, and response number 3 received by the mother. So far as steps by registered post is concerned, comma, response number 1 so far as response number 1 is regarding steps by registered post, comma, so far as response number 1 is concerned, comma, AD card has been received back without any signature. Semicolon. For response number 2, neither AD card nor unserved notice received back. For response number 3, AD card received back without the signature of the respondent. Full stop. Para. Since we'll pass some different order. We'll have it for consideration. Since the contesting respondent, namely the insurance company, has been served as per the service report, please this case for consider for admission on when? Wednesday next?
Lordship.
Wednesday.
Lordship, otherwise the insurance company appeared, Lordship.
No, we'll dispose this of. We'll not have it because we'll go by the service
EPO.
report. Origin question. You can hand this over on the next day.
Lordship.
Just a minute. Yes.
Maybe your lordship.
Yes.
Your lordship, I filed this appeal
Madam Borua, you just take this. Next day you please.
against the impending order dated.
Yes,
Your
sir.
lordship, I filed this appeal
Yes.
against the impending order dated 6/6/23 passed by the learned trial court refusing to grant injunction. Your lordship is cited. Page 75 in the
First
memo.
appeal lies here.
Yes, sir, lordship.
What kind of injunction did you seek for?
Your lordships, I sought for the injunction restraining the defendant number, permanent injunction restraining the defendant number 3, his man, agent, workman, employee, or any person claiming through the defendant number 3 from changing the nature character of the schedule A1, C to H property in any manner.
They had taken, how has it, how have you come to the property?
Lordship,
Okay.
I am appearing for State Bank of India.
Yes.
Now, this is the third round of litigation.
The suit for what?
Suit
Suit
for your
for
declaration.
partition.
No, not partition.
Yes.
Suit for declaration and permanent injunction. You are.
What? This is the copy. Is the title book number 25?
No. 25.
Yes.
Suit for declaration and permanent injunction.
Suit for declaration and permanent injunction. Rupees 11,000 is paid for partition.
Your lordship, this is
the plain copy of the plaintiff.
Your lordship, this may be the mistakes,
No.
but the prayer may be considered, your lordship.
In the second round of litigation, so another suit was filed between the same parties. My lord will see.
Declaration of
Declaration, your lordship, my
permanent injunction
permanent injunctions.
and partition also.
Yes.
No partition, no partition.
Okay, let us see the prayer.
Prayer is at page 25, memo appeal, your lordship. Page number 41. My memo appeal may be. Got it, your lordship?
Perhaps it is not for partition.
Your Lord.
Some mistake has come.
Let him complete.
It is not for partition.
It's for declaration and permanent.
Declaration.
Your Lordship,
And you had filed, then what had happened?
therefore, your
Who are you?
I'm
How is
the,
it connected plaintiff?
Your Lordship, I am the plaintiff in this case.
Understood. How are you connected with this?
I am connected, Your Lordship, because this properties upon which the mortgage are created and everything happened.
You
Your
are the
Lordship.
owner of the property.
I am owner of the property by way of inheritance, Your Lordship.
Inheritance.
Your Lordship. Your Lordship.
Then what had happened?
Your Lordship, I want to brief Your Lordship. My father is Ganesh Sekia,
Ganesh Saikia.
Your Lordship.
Father.
Ganesh Sekia expired on 24/1971.
20?
24/1971.
Okay.
My mother is Renu Sekia.
Okay.
She died on 18/7/2001.
2001.
Your Lordship. My father was the owner of two plot of lands, one bigha covered by dag number 241. Second is 4 bigha 3 kata 142 covered by dag number 286, and both the land covered by pata number 40.
Okay.
Village Naw Khalgaon, Moja Goba, Morigaon. My mother purchased a plot of land measuring 8 bigha, that is the annual pata lands, Your Honor, by sale deed dated 12/12/1966.
Yes.
So these are the lands which purchased and inherited by me, Your Lordship. Your Lordship, the legal heirs herein. I am the Lina Sekia, the plaintiff in this case, plaintiff petitioner.
You are the sole legal heir.
No, Your Lordship, there is a lots of legal heirs.
Yeah.
Second is Sanjeev Sekia. Third is Julie Sekia. Fourth is Poli Sekia, Bobby Sekia, Lucas Sekia died, and their legal heirs. All are the party in this case. So, Your Lordships, as my mother and father has this property, on his demise, this property devolved upon us as an inheritance. What when in this case, Your Honor? So, Your Lordships, what when in this case?
Yes.
My brother, the appellant number 3, he got some document executed from me and other legal heirs, Your Lordship, under the pretext that, Your Lordship, the second lands which purchased by mother is a annual pata lands, and that to be converted into the pata lands, Your Lordship. And second pretext on which they took my signature, Your Lordship, to Your Lordship construct a factories over the property. So these are the two pretexts on which the documents are taken from me.
By whom?
From the other legal heirs. Sanjeev Sekia has taken those documents from other legal heirs, Your Lordship. The other sisters. Only one boy is Sanjeev Sekia and all other the daughters.
Yes.
Thereafter, Your Lordships, they converted these documents into some affidavits and declarations. And Your Lordships, this annual pata ultimately settled in the name of all the legal heirs, Your Lordship. 1 bigha 2 kata 18 lesa, like this, it was settled. It is also reflected in the Jama.
1 bigha was converted.
Out of 8 bigha, 7 bigha converted into the pata land, Your Lordship, Medi pata land.
Yes. Then
So Your Honor, Your Lordship, as my brother, this is the Sanjeev Sekia has taken those documents from me. They converted it. Actually, those document was taken, the signature was taken only for the pretext of conversion of the land, as well as for construction of the factory and all this. With the condition that after construction of the factory, your lordship, they execute a lease deed in my favor and ultimately give some rent, your lordship.
Okay.
So on that basis, everything happens.
Okay,
What he did, your lordships, he converted those documents into the affidavits in form of no objection like that, and a deed of declarations. So by that, your lordships, they struck out my names from the Jamabandi, saying that
These signed papers were misused.
and all these properties which belong to all of us, the Sanjeev Sekia said that it is belong to me. Another plea was his taken, your lordships. Your lordship, when I come to know regarding this fact, your lordships, I asked my brother, the defendant number respondent number 3 herein, to partition the suit land. All these belong to us, your lordships. Then he refused, and ultimately I filed a suit for partition, your lordship, other round of litigations. And I have filed, so lordship, my I may be taken that I filed order 913 1 and 2, your lordship. Therein, I filed the suit.
Page
68.
Your injunction petition.
In injunction application, all the documents is there.
68.
68. This is my suit for partition, your lordships.
Of the IA.
Of the IA, lordships.
Now tell us what has happened. What
Here, lordships.
Let us see the orders.
Your lordship. Order is that your lordship in memo appeals.
Yes.
Page 75.
66.
Your lordship, 623.
66 order.
Your lordship.
By whom?
By the your lordship civil judge Morigaon, your lordship. In Mijay case number 2223, 2023. Arising out of TS 25, 2023.
Okay.
Your lordships, had this, your lordship, the learned trial court refused to grant injunction, your lordships.
No, it's not refusal. It has ad interim.
Ad interim not granted,
Not
your lordship.
granted. Where is the refusal?
On ad interim not granted. Yes, sorry, your lordship, ad interim not granted.
Notice has been issued.
Yes, notice has been
It's not a
issued.
question of rejection.
Yes, yes, it is not a question of rejections, but notice has been issued. Your lordship, notice has been issued by not granting me the injunction because I pressed for the injunction, ex parte injunction.
I am of the view that hearing of the other side is
Necessary, your lordship.
has no effective.
Order is passed.
Issue notice.
Your lordship.
This is not a rejection.
Your lordship,
The next date fix.
the next date fix
15/7.
on 15/7/23.
What happened?
On that day, your lordship, all the party appears and they took time, your lordship.
Then
Yeah.
we fix
Your
the
lordship,
date, fix the date for the planet trial court. We're not fixing.
my humble submission, your lordship.
We'll make a request to the trial court to consider.
Let me complete. I will
Then
praise,
in the
I'll
meantime,
praise everything if you
your lordship, I am also
How-
praising my learned friend, what my learned friend is saying, your lordship, herein. One round of litigation is a essay, your lordship, where my learned friend appears, this sufficient applications. And his stand is that by way of affidavits, I have relinquished my right. Whether by the way of affidavits, whether right can be relinquished. This is your stand,
See, that is the subject matter for different proceedings.
your lordship.
We may not be inclined to go into that proceeding.
But-
Now, here we have an order of 6/6/2023.
Your lordship.
By which your prayer for injunction has not been rejected. Yes, it is correct that your prayer for administrative does not appear to have been passed.
Your lordship.
But notices have been issued, and you say on the next date, 15/7/2023, the contesting parties have appeared.
Your lordship.
Now, what is the next date?
That you know that.
Next date, you sort it out, you find it out.
Your lordship, but you're in the
If
meantime,
if you are aggrieved by non-grant of injunction, we are there.
in the meantime, your lordship, I may be protected, your lordship. No.
Now, what is your apprehension? What is the,
apprehension, your lordships, that the defendant number 3 herein, your lordship, they are going to construct the, your lordship, change the nature and character of the suit line, your lordship.
how are you, how is the bank involved?
Lordship, let me complete.
Bullet.
Now, Lordship, I am coming to the activity.
How is the bank involved? Just tell us.
This defendant number 3 has taken loan from the State Bank of India.
Or with this land,
This various land,
along with this land.
along with this, by submitting patta in his own name. It is thought that the patta title deed deposited with the bank is in some other names. The bank has duly verified in the land records, their name is not there.
Have
That-
you filed application for correction of your land record?
No,
Is
no,
that-
no, no,
Your lordships,
no. No, that is not their
I
submission.
have no.
That is not their submission.
No, if you think that there has been some error in the land record, you can very well.
I can, your lordship, I can go to that revenue,
Yes, yes.
your lordships. But in the meantime, your lordships, the manner in which a mortgage was done, your lordship. One of the important thing in this case, your lordships, this land was settled in my names, even by his, in the name of my
Mr.
brothers.
Jha,
So there,
you may be correct, but there may be an angle of connivance also.
Yes, that is the thing.
your lordship,
Lordship,
Your brothers and sisters, one brother,
one of the
Yes.
director, Lordship, one of the director of Access Bible
your lordship,
is the husband of the petition applicant.
your lordship, my
Is the
humble
husband
one
of the
submission, your
applicant.
lordship, my
I-
one submission.
I am just coming one by
My
one.
one submission.
No,
one
no,
submission.
if you,
You may submit, one submission,
Okay.
your lordship. Your lordships, when a bank can go for mortgage, your lordships. Whether it is not the duty of the bank to go through all the legal years, your lordship, first lapses. Second was the blunder is your lordship. The land, the annual patta land was converted into my lands.
Nandi, what are you contemplating with the land?
the land mortgage to the bank is a periodic patta land.
No, what are you contemplating to do anything with the land?
Yes, Lordship, the account has become NPA.
It's already NPA.
NPA. Now they have filed surface application with the bank. The original application we have filed in the DRT that was allowed.
Sir.
There is a valid decree in favor of the bank. Now they have filed surface application. They have not got any relief.
Services connected with the same land.
Yes, in connection with the same land, they have filed
Yes,
surface
Your Lordship.
application. Let me complete.
I think the trial court has done wrong in not rejecting your case.
Your
They
lordship,
have
it
filed
should have been
surface. There are
your,
two levels of surface application. One is by them and another by the.
Mr. Nandi, you come to this side. You should be aggrieved why injunction has not been rejected. Under those
There is a limit of hand in
We'll
hands
allow you.
within the brothers.
your lordship, my humble submission, your lordship. What he did, your lordship, first, your lordship, to creation of mortgage, it is not the easy thing.
Mr. Jha, if you make more submissions, something more will come out now. We are already,
No, your
we are
lordship,
already convinced.
only one thing I want to say, only one submission, your lordship. His conduct, your lordship, 2009 land,
If you come to conduct,
your
you'll
lordship,
be in great difficulty.
yes, your lordship, but in case of mortgage,
We thought of
Conduct, I would
dismissing,
give his
then-
conduct.
If we are thinking of dismissing, then if you talk about conduct, we'll impose.
no, your lordship, that. But I am not the conduct, I have the manner, procedure, your lordship.
Heard. The and council. You're on caveat.
No, I just,
Notice was issued over.
no, nothing you should do the first day. I've
First day.
gone through the cause list. I'm happy.
You
I
have
know
noticed-
he will do something.
Without Wakalatama, your lordships.
That-
Why have it?
That will permit. That's not an issue. Heard and council for the appellant who has preferred this appeal against an order dated 6/6/2023 passed by the learned civil judge Morigao in mid case number 22 of 2023 in connection with title suit number 25 of 2023. Full stop. This suit has been filed for declaration and for permanent injunction. Full stop. Para. By the impugned order, comma, the learned civil judge has issued notice in the application filed under Order 39, Rule 1 and 2, read with Section 155, 151 of CPC. Full stop. Para. Three, the learned counsel for the learned counsel has submitted that the suit property has been inherited from their predecessors, namely Ganesh Saikya, within bracket father, and Renu Saikya, mother. And there are a number of siblings. Full stop. It has been contended that certain signatures were taken from the appellant by one of the brothers on the pretext to convert a part of the suitland which was annual periodic, which was annual patta, to and also for construction of certain factory. Full stop. However, comma, the signed papers were misused, whereby the name of the petitioner was removed from the rights from the record, rights of record, records of right pertaining to the land, and the land was given on mortgage for a loan taken by the state brother. He accordingly submits that unless ad interim injunction is granted, comma, irreparable loss and injury would be suffered by the appellant as plaintiff, and there is a prima facie case to go for trial. Para. Per contra, comma, Sri Nandi, who has entered appearance by filing Wakalatama today,
Yes,
has submitted
for respondent 1 and 2.
for respondent number 1 and 2 has submitted that there is absolutely no error in the order dated 6/6/2023, and rather he submits that it is a fit case where injunction, where the prayer of injunction should have been refused. Also, he submits that the suit appears to be a collusive one, inasmuch as pertaining to the state land, there was originally a proceeding under the DRT Act, followed by a present proceeding under the Surface Act. And the husband of the appellant plaintiff is one of the directors of the company which is involved in the borrowing. After hearing the parties and on perusal of the materials on record, comma, this court is of the view that since the order dated 6/6/2023 has not discussed anything on merit, comma, at this stage, comma, this court will refrain from making any observation on the inter se merits of the case. However, this court has noticed that the prayer of injunction has not been per se been rejected, has not been per se rejected, and rather notice has been issued with the next date, by fixing a next date. This court has also been informed that the parties contesting parties have entered appearance. Full stop. In that view of the matter, comma, this court is of the considered opinion that interference by this court as a court of appeal at this stage would not be warranted, and rather the discretionary power is to be exercised by the trial court on the next date. Full stop. The parties would be at liberty to put forward their respective cases while considering the prayer for injunction. Feel according to the
Obliged.
Please, you can take it back, Mr.
Okay.
I close in view of the order final response today.
Main task.
This also
Yes, yes,
final response in the FA of the
Yeah.
no order is required to pass in the according to the close. Yes.
May it please, my lord.
Yes.
My lord, this is an appeal, my lord, preferred under order 43 rule 1R, my lord, against order dated 27/2023, whereby my prayer for ad interim injunction was not granted, my lord. Impugn order is at, my lord, page number 83, my lord.
83.
83, and operating portion is from page number 87, my lord. Before going to the operating portion, my lord, I filed the suit as a plaintiff, my lord, for declaration of my right title interest.
First, let us have a look at the
My lord.
order, then we'll come to the
Definitely.
your submission. 87.
87 is the operating portion.
What is the next page 20, page 88?
It
Oh,
is
87.
87.
It starts at 83.
83 it starts, my lord, with the facts of the case. 87 operating portion. Discussion.
You are the plaintiff.
I'm the plaintiff.
Suit for
Suit for declaration of right title interest, confirmation of possession,
appellant plaintiff. Suit for declaration right title interest.
confirmation of possession, and permanent injunction not to dispose this matter.
Permanent.
My lord. 87, may I read, my lord?
Yes.
Peruse the materials available in the case record, which prima facie shows that there is a gift deed in favor of the plaintiff petitioner over the suit land covered by Dag number 47, KP Patta number 541, executed by late Bina Chaudhary. Materials available in the case record further reveals that land covered by Dag number 46 is towards the southern portion of the land covered by Dag number 47. Dag number 47 is the suit land. Further, from the materials available in the case record, it reveals that the OP number 1 had initiated a demarcation proceeding for demarcation of land covered by Dag number 46. And in the said demarcation case, the circle officer had issued notice to the present petitioner along with other co-owners of Dag number 46 to attend the process on 21/6/23. Perusal of the record reveals that on 21/6/23 itself, the circle officer, in terms of the order of Honorable Guwahati High Court dated 2/9/22, passed in WPC number 5706 of 22, had issued face notice to the co-pattadas of Dag number 46, covered by KP Patta number 56, thereby fixing the date of hearing on 4/7, adjourned to 27/2023. I have perused the order of the Honorable Guwahati High Court dated 2/9/2022, passed in WPC number 5706 of 2020, which reveals that the process of demarcation carried over Dag number 46 was put on in the said writ petition. Further, it reveals that the circle officer Azara Revenue Circle, by referring to the said order of the Honorable Guwahati High Court, had cancelled the notice number so and so, that is the document number 12, and had fixed 4/7/2023 for hearing of the co-pattadas, including the present petitioner, in connection with the demarcation of land covered by Dag number 46. Further, from the injunction petition itself, it reveals that the said demarcation case is fixed for today for hearing. Upon consideration of the fact that the parties to the present injunction petition are again called for hearing in respect of the demarcation of Dag number 46, by of cancelling the earlier notice, the document number 12 prima facie appears that at present there is no urgency so as to pass any effective order in respect of Dag number 47, which is not the subject matter of the demarcation case. My lord, here the learned trial court did not consider two facts, my lord. That on 21/6/2000.
What is the urgency involved?
Urgency, my lord, there is urgency because, my lord, on 21/6/2023, when the
land revenue staffs along with the respondent number 1, they came to the dark number 46 for demarcation, my lord. They tried to grab the land of their dark number 47, my lord. They came with hired elements, my lord, around 200 persons, my lord, both men and women with JCB, my lord. In dark number 47, my lord, the plaintiff is a society, Srimata Honkar Academy, my lord. They parked their vehicles. They tried to demolish the vehicles, take away the vehicles also, my lord. Similar incident happened on, my lord.
Who are the respondents?
Respondent 1 is, my lord, Bina Chaudhary, my lord, the main defendant. And the others are, my lord.
Nani Chaudhary.
Bina Chaudhary. Nani Chaudhary, my lord, sorry.
Nani Chaudhary and only respondent.
There are 5 defendants, my lord. Defendant number 1, she sold land.
No, you have made only one respondent.
Main
Respondent attached.
Achha, one response. Because
She's a lady.
She's a lady, my lord. But
Ah.
she comes with, my lord, 200 persons, my lord, both men and women, along with JCB and all, my
Let
lord.
us see your plate where you made the statement.
My lord. That, my lord, will find at paragraph number 7 of my claim, my lord.
Page number 30.
Page
Paragraph
number
number?
30, my lord. Paragraph number 7.
It's 30.
30, my lord.
Yes.
That on the para 7, my lord, that on the date fixed, that is on 21/6/2023, the officials of the plaintiff society were present in the office of Girjananda Chaudhary Institute of Management and Technology, Ajara, at the scheduled time, and accordingly, the circle officer, Ajara Revenue Circle, accompanied by his revenue staffs along with defendant number 1 and her associates, numbering more than 200 people comprising of men and women, and the police officials of Ajara Police Station gathered in the National Highway near the campus of the institute. But surprisingly, the circle officer, Ajara Revenue Circle, and his associates, instead of entering into the land of dark number 46, entered into the land of dark number 47, that is the suit land, through a passage situated over the adjoining land of dark number 44.
This gift deed pertains to suit 47. Therefore,
47.
gift deed is a registered deed.
Registered gift deed, my lord. I have annexed it, my lord, at page number 59.
When is the next date? 23.
23/8, my lord.
What is your apprehension?
Apprehension, my lord, they have similarly tried in the month of February also. They tried to dispose me. Again, they have tried in the month of June, my lord, July. So, my lord, we have every opportunity, my lord, they might.
Suit is pending.
Suit is pending, my lord, but they have, in spite of receiving a notice, my lord, they might dispose me, my lord. So, if an order of interim protection with regard to only dark number is 47, my lord. Status quo, if it is maintained, my lord, then, my lord, at least, because twice they have tried to dispose me, my lord.
Heard. You have filed an injunction application.
Injunction application, IA 206.
Heard. Three equal. Learn it. Why two cases? Also, one is IA.
IA.
Learned counsel for the appellant who, by means of this appeal, appellant who has preferred this appeal against an order dated 27/2023, passed in Miss J case number 744 of 2023, arising out of title suit number 442 of 2023, passed by the learned civil judge number 2, Kamrup M. Uttam. The appellant who is the plaintiff had instituted title suit number 442 of 2023 for declaration of right, title, and interest, confirmation of possession, and also for permanent residence. Full stop. The source of right upon the suit land covered by doc number 47 is based upon a registered sale, a registered gift deed. Full stop. Sarah, the equal the learned counsel has drawn the attention of this court to the specific pleading made in paragraph 7 of the plain that the defendant had come with a number of persons and instead of the land covered by dock number 46, the land covered by dock number 47 was also thought to be affected, and there was almost a law and order situation. By drawing the attention of this court to the order dated 27/2023, which is the subject matter of appeal, the learned counsel has submitted that two notices have been issued, no ad interim order has been passed with certain observations regarding urgency, which perhaps are not sustainable in fact as well as in law. He submits that unless an ad interim injunction, under an order of ad interim injunction is passed, serious irreparable loss and injuries could be suffered by the appellant plaintiff. Full stop. When is the next date fixed?
23/8, madam.
Admit. Full stop. Since the next date is fixed on 23/8/2023, this court is not inclined to call for the record at this stage. Full stop. Let's step for service of notice. Notice upon the sole respondent be taken by usual process as well as by registered post.
My lord.
Steps by Monday. List on 23 you have said.
My lord.
On 30th of August 2023 for service report. The IAU, right? But the equal learned counsel for applicant who by means of this application made under Order 39, Road 1 and read with section 151 has paid for a temporary injunction. The connected appeal against the ordered dispense passed by the learned has been admitted, and the next date has been fixed on 30th of August 2000. The learned counsel has submitted that the next date is 23/8/2023, and in the event some interim protection could not be granted from irreparable loss and injury would be suffered by the appellant plaintiff. The counsel has also submitted that in the impugned order, the existence of a registered gift deed in favor of applicant appellant plaintiff has already been recorded. In view of the above, this court is of considered opinion that interest of justice would be met immediately if an order of maintenance of status quo over the suitlet covered by doc number 47 is passed through subpara accordingly, comma, till the returnable date, comma, let there be status quo maintained so far as the suitlet covered by doc number 47.
Of patta number 541.
Yes, patta number
541.
of, give the description, 541 of
541 of village Azara, Moza Ram Sorani.
of village Azara, Moza Ramsar. According to report,
Deeply obliged.
I think we have to know, issue notice here.
My lord,
It not be proper. For issue notice. Actually, for on the date. Or step.
Within month.
Within month. That's hard. We'll have to keep this alive. This is an injunction application.
My lord, my lord.
Without hearing, we cannot.
Definitely. Deeply obliged.
Yes,
May please, Lordship. So this is a statutory appeal whereby my application for appointment of receiver had been rejected.
Under 41?
40, under 40.
40.
40. Lordship, at this stage, Lordship, since it's an appeal, Lordship may admit the appeal and issue note. I have also filed an application.
Appeal lies.
Appeal lies.
Under 41 rule 1 of what?
Under 41 rule
1, what? R or not R?
No, not R. I think you. I'm just checking. S, madam.
Against rejection of a application for.
Yeah. Yes, sir.
Hard to repeat and it counts. What is the IA for?
I'm for the appeal in Lordship.
No, IA for?
IA is there, Lordship. I filed a separate IA for again for appointment of receiver. A notice will be issued in that.
Hard repeat and counsel for the appellant who has preferred this appeal against an order dated 12/5/2023 passed by the learned
additional session judge number 2.
It be district judge. Don't write him session judge. Exercising powers under what powers? Land grabbing.
This is land grabbing.
Land grabbing.
Yeah.
Okay. Special judge.
Yes.
Additional district and session judge number 2. Kamrup.
No, madam, Nagaon, madam.
Or Nagaon. This order 40 will be applicable.
Yes, my lord, because first, my lord, as per the act of the land grabbing act, first the civil side has to be decided. After that, my lord, the criminal liability has to be seen, my lord, weighing with the whatever has happened in the civil side.
What is the proceeding registered as?
Proceeding is registered as Lordship, special land grabbing case number 5/14. The act itself provides for it, Lordship.
Nagaon in petition number 343/2020 filed in special land grabbing case number 5 of 2014. Also, by the impugned order, the prayer made for appointment of a receiver has been rejected. There I admit, there I call admit let them for service of notice upon the sole respondent be taken by the process as well as by the proceeding. Service by Monday. List on.
But this may be admitted, madam.
Which is admitted. List on. Supported conflict. List on 21st of August. Or 2020. And it again. I take a issue notice. Registered user process registered. Highly objective. Rest, this should be. Any matters where interim order needs to be extended?
Item number 47, there is some urgency. Can it be fixed on Wednesday next?
Dates still give.
The interim orders.
Lordship,
Since item number 48, my lord. And lastly, I also pray with lordships. Since interim order had to be passed, my lord, in the case, and my lord, can it be on Tuesday, lordship?
Date he'll give, date don't worry. He'll give only matter where interim order needs to be extended.
Yes.
Lordship,
That's
item
the urgency in my case.
60,
No, interim order which needs to be extended today, which is up to today, only mention those now before the court. Otherwise, dates court must have give.
Yes.
Lordship, I mentioned item 63, Lordship, to be listed today because we wanted a stay order in this case. Day before I mentioned. it.
Date he'll give.
No, not date, Lordship. I need a stay order because the appeal was.
Without hearing, can we, how can you go?
Yes, Lordship.
We'll
So
give an early date, to try to have an early date, Tuesday.
on Monday, Lordship.
Monday it will not be possible. Tuesday. Mr. Raf,
My lord, there is a fresh matter. So can it become out next Monday, my lord?
Monday, next Monday. No.
Tuesday?
Tuesday,
Let it be Tuesday.
he'll give dates, don't
Because
worry.
the injunction, I pay for injunction, that's right.
Tuesday order matters, my lord, did Wednesday, my lord, if possible.
Oh, not on Wednesday. Orders, if you can try to have it on Friday. Next Wednesday.